the date set.
We'll take it up as the first item today.
I have
Please, Your Lord. I beg to mention item number 12 of today's list, my lord. In this matter, I was directed to obtain instruction in the matter, my lord. I have some genuine difficulty, could not get hold of the instruction, and I have a prayer for adjournment, but I could not get the consent of the other side, my lord. So my prayer would be, my lord, when the matter is taken up, Lordship may kindly accommodate me today.
Your Honor, may permit me to mention item 8, 9, and 10. The three Oil India matters regarding applicability of GST. I've moved an adjournment slip in this matter because that's the arguing counsel, Mr. Arvind Datar, is front of the Supreme Court in a constitutional bench matter. It's expected to take long. Your Honor may consider having the matter tomorrow or not any other.
This matter pertains to what?
Your Honor, this is with regard to the applicability of service tax in three connected writ petitions. Two of them is regarding GST and one is regarding service tax. And we are saying that since Oil India is an oil extracting company, so we pay royalty on the extraction of oil. The question is whether additional service tax or additional GST is payable on royalty. So it is our case that it is a case of tax on tax. You cannot put a tax on a tax. The respondents will have different views. That's the gist. The bunch of connected matters that are going all over the country with regard to for all oil producing companies.
8 to
10,
10.
8, 9.
The request of the learned counsel for a petition. Matter stand adjourned for 6
What?
months.
No, may not. Tomorrow, day after, your
No. It can't be at your accommodation.
any date, Your Honor.
Okay.
We're prepared with the matter. Take a date, one day. Conclude.
On 15th of November.
15th of November. Item number 2, my lord. The matter regarding department processing and it was against Hindustan Pepper Mill matter. That has gone into liquidation. So otherwise, my lord, the party wants the case to be withdrawn. You would hesitate before the liquidation. So nothing
You
left.
wait for some time.
I beg to mention for listing its case, my lord. In March, it was listed. Instructions.
Court number 5.
Item number 1.
Item number first is item number 17. Yes, familiar input.
last page of the instruction is different.
Yes, what is your case? What are you saying?
It is an expert regarding regularization.
Or regularization of service.
I was supposed to take instruction whether petitioner was continuing from 24/10/2005, my lord. The department says he is not continuing, my lord, and that his certificate is also here.
The instant writ petition was filed by the petitioner claiming regularization on the basis of the government notification number BFV.475/02/PT/89 dated 30/9/2005, the benefit of which have been given to some other similarly situated person. This court, by an order dated 17/8/2023, had sought for instruction as to whether the petitioner still continues to render service after he joined on 20/10/2005. Ms. M. Borman, the learned counsel appearing on behalf of the respondent submits that with effect from 24/10/2005, the petitioner have not been
Continuing, sir.
continuing his service. In that regard, a set of instructions have been placed before this court, which is kept on record and marked with letter X. The learned counsel for the petitioner further also submits that in the meantime, the petitioner had also expired. Taking into account the above facts, this court is of the opinion that the writ which had been sought for cannot be issued, taking into account that the petitioner had expired and the cause of action in respect to the instant writ petition dies with the petition. Accordingly, the writ petition stands.
Of life.
Yes, Mr. Dasgupta.
Item 1.
Yes, affidavit filed. Where is it? Who? Where is the affidavit?
Paragraph 6 is the relevant.
Yep. That as regards the first query raised by the court, to the effect that in absence of the certified standing order stipulating the age of retirement of the person, what would be the age of retirement in private practice in the state of the deponent while stipulating the age of retirement of the person in terms with the draft industry employment with the age of retirement pending finalization. So as per them, it is, as per para 4, it is 58.
No, what is their contention? That is not correct. And if we accept their contention, it will create some problem. Because what they wanted to say, we don't have any model standing order. Though we have prepared a draft standing order, but that thing has not come into force.
Industrial standing
So
order
what they
has been
wanted to
brought
say
into force.
that
Opponent says
at
that
present, there is no
PLP
such model standing order in the state of Assam.
is the draft.
So for my case is
Whether the
concerned,
will IB
I am
prevail in
all right.
absence of the
but it will create some consequence for the other cases that would if we accept their content.
section.
Let me read paragraph 6. As regarded,
So as per them, that will not apply.
yes,
Central rules won't apply.
but it will apply
Why?
because below industrial employment standing order was enacted. Under entry 24 of the concurrent list. It is a concurrent list subject. Because
Where's the central rule?
central rule is
Central rule for nothing. Industrial.
Janani. For the timing, your lordship may take my,
এইখন কিতাপ এইখন
এখন অসুবিধা পাব বটে এখন দিয়া মই
Just will take- Oh, yeah.
Well-
Yes,
standing rules, Lord.
you are understanding rules. Okay.
Now, my lord, this act was, if your lordship goes to the preamble of this act, my lord,
Which one? This one?
or the preamble of this act,
Act of 1946
46, Lord, I don't,
to require employers in industrial establishment formally to define the conditions of
condition of employment under them and to make the state condition known to the workman to them. So basically, it is for the condition of the workman.
begin to require employers in the Then
Then, my lord, your lordship, for the timing, if your lordship comes to Article 42. This is a
inaccurate.
42 and 43.
Okay.
Right. Your lordship, you can take up my book. It's up to the chairman. Well,
No, it's okay. Let us, today I have a lot of time, being a Tuesday, not in urgency. No, you can go ahead. We'll ask these people to be more careful in keeping the book, not in this manner, just to find out this book. Yeah. वो सब ठीक करा ना कॉन्स्टिट्यूशन याद थी बोले और याद की मैं डाउन के कॉन्स्टिट्यूशन नेता से पीछे न पे yes
my lord, have a look on Article 42 and 43.
इकोनो किताब कौन लिखा है two yes this is fundamental duties
No, directive principle.
directive
Directive
Yeah.
principle. No, provision for just and human condition of work and maternity relief. The state shall make provision for securing just and human condition of work. Now, my lord, preamble, we have seen that is a condition of employment. So,
yes
now if your lordship come to Article 43.
Mm.
The state shall endeavor to secure by suitable legislation. This is the suitable legislation. There is the Industrial Employment Standing Order. Or economic organization or economic concern in any other way to all workers, agricultural, industrial, we are industrial, or otherwise work, a living wage, a condition of work. Ensuring the decent standard of life, etc. etc.
then
Now your lordship come to the concurrent list.
yes
Concurrent list item 24.
okay welfare of labor, including conditions of work,
Condition of what?
provident fund, employment, work
Hmm.
compensation, and old age pension.
So,
So here, both the state and the center
Yes.
would frame laws.
can frame law.
And here it has been done, you are saying this standing orders, the Act of 1946 is done. This can't be done. This is the old one. This was prior to the constitution coming in.
But it is in consensus.
So this was done under the 1935 Act.
They certify that.
And what was the parameter provision then? What was the parameter provision then? Because we are saying about the 1946 Act. Constitution came in 1950.
Because there are some provisions of the government of India, probably I am not clear on that, on this point. Some provisions of the Government of India Act has been incorporated in Article 246, 47, 48, 49, 50.
No, maybe, but that is it. But if you are trying to make a submission on the basis of 42, 43, and as well as entry 24 of the list
Yes.
3, then, and you say that on the basis of that, this has come in. So obviously, then we have to go into the Government of India Act, because this happened at that point of time.
Take judgment. Immature. Okay, but look, this aspect of this case was considered in several judgments.
Hmm.
Some of those judgments are plus 1978 4 SSC page 16.
What does it say?
Mhm.
What does it say?
That is I'm coming. And other judgment, I'm just referring to. Okay.
So here, therefore, the question is as to whether this
So I have
act,
to that judgment. And
no,
in
whether
that
this
judgment-
act will be applicable insofar as the state is concerned.
Yes, yes.
That is the main consideration. Now, this act categorically says at section 1, this act may be called the Industrial Employment Standing Orders Act 1946. It extends to the whole of India.
Yes.
Now, interestingly, it applies to every industrial establishment wherein 100 or more workmen are employed or were employed on any day of the preceding 12 months. Provided that the appropriate government may, after giving not less than 2 months notice of its intention to do so, by notification in the official gazette, apply the provisions of this act to any industrial establishment employing such number of persons less than 100 as may be specified in the notification. Now, the appropriate government has been defined in section 2B.
Yes.
Appropriate government means in respect of industrial establishment under the control of the central government or the railway administration or in a major port, mine or yeah, the central government, and in all other cases, the state government.
State government.
Meaning thereby, this act also applies to the
Yes.
state government.
Yes.
Now, if the act applies,
Applies
would
to
the
government
rules
as well as central
frame,
government.
now let us see the rules. Now, the power to make the rule.
Rule or to make the rule, find section 15.
Yes.
Section 15.
The appropriate government may, after previous publication by official notification in the official gazette, make rules to carry out the purpose of this act.
Hmm.
In particular, and without prejudice to the generality of the foregoing powers, such rules may prescribe the additional matters to be included in the schedule and procedure to be followed in modifying the standing orders. Set out standing orders for the purpose of this act. Prescribe the procedure for certifying, prescribe the
Now,
Now.
now
these
you are also
rules-
come to schedule.
Hmm.
What are the matters to be incorporated in a standing order?
No,
is
no,
your
no. If you see the rules of 1946,
Yes, yes.
they extend to all union territories and shall also apply in any state or other than a union to industrial establishments under the control of the central government or the railway administration or in major port, mine or oil field. So these rules, the power to make the rules have been conferred upon the appropriate government.
Yeah.
It may include the state government or the central government. The act definitely apply. Now, whether Sam has made a rule, where's the
Assam has
rule?
not made a rule. There is a draft of it.
Assam Industrial. So they have made these rules. Hmm. Now here there is no age. There's nothing about the age.
Milord, when this rule was framed
Hmm.
in the year 1987, sorry,
47.
1947,
Hmm.
incorporation of age was not there in the schedule.
Incorporation of
Age in the standing order. People also goes to the schedule first.
schedule.
Schedule appended to this act.
Yeah.
Now, matters to be provided in the standing order
Hmm.
under this act. Lord, your lordship will find all these things, excluding the retirement age.
Excluding.
Retirement age. There is nothing mentioned about the retirement age. Now, item 11,
Any other matters which may
yes,
be prescribed.
item 11, any other matter. In exercise of this power, any other matters, if you are allowed to go through the standing order central rules 1946, you also will find rule 2A was inserted in the year 1983. You got it?
Hmm.
Rule capital 2A, where
After item 10.
10A and 10B.
Age of retirement.
Hmm.
10B.
10B.
So this is there for the central rules, but not in there. There is no amendment to the state. So that is why you have this 1985 draft rule. So after the 83, they must have thought about making in Assam also. But the state government is in deep slumber.
So what will be the fate of this establishment where there is no such standing order? Now, for that purpose, I would like to invite your lordship's attention to section 12A.
Hmm? 12A
12A, capital A,
of the Act.
Act.
12A, yes.
Temporary application of model standing orders. Notwithstanding anything contained in section 3 to 12, that is the procedure about the framing of the standing order. The period of commencing on the date on which this act becomes applicable to an industrial establishment and ending with the date on which the standing order as established, standing order as
Yes.
finally certified under this act come into operation under section 7, and in that establishment the prescribed model standing order the prescribed model standing order shall be deemed to be adopted. Shall be deemed to be adopted in the establishment, and the provisions of section 9, subsection 2 of section 13, section 13A shall apply to such model standing orders as they apply to the standing orders so certified.
Now, whether the Assam Industrial Standing Order rule have a model standing order? You have a model standing order. It is there. So that will apply.
Schedule 2,
Schedule 1.
Schedule 1 and Schedule 2.
The Schedule 1 of the rule. That's the model standing order.
It is a plantation.
No, for factories and so. For plantation and factories there is.
For industry, it's schedule.
Huh?
For industry, it is schedule.
Model standing order for other industrial establishments.
Ah. So here you have a 8.
No.
For the termination, for terminating employees of a permanent when notice in return shall be given of 1 week in case of a monthly rated and 2 weeks in case of a water workman, 1 month. No temporary worker. So, how do you apply? You can't apply the central because you have a model out here.
No, I have a model undoubtedly, but this model does not contain about the retirement age.
So then how do you apply?
So the central government has framed their standing order in person to this power conferred under the schedule itself. And in that standing order, the retirement age has been set. Now, Milord, it is basically a subject matter of concurrent good. So if we go to, if there is a provision under the contract, concurrent list, act under a concurrent list, it will be applicable to in both the state as well as the central government. State government. as
Although
well
the
as central
state
government.
have,
It is a act. made
although
by
the
parliament.
state intentionally have not put the age.
Milord?
Although the state intentionally did not put the age. Because they could have very well.
No, we intentionally did not PGA for the betterment of the workers. Because the so far subject matter of the fixing of date of retirement is concerned, it should be by the mutual agreement between the employer and the employee. Or it may be by a way of settlement. Or it may be by way of award. If there is no such thing, then the provisions of the standing order will be.
Understood. So they have a standing order.
Yes.
The model standing order is there. If
Yes.
you are going to section 12A,
So,
you'll have to apply only the model standing order. How can you then incorporate the standing order, model standing order framed under the rules which squarely does not apply to the state government?
no, standing order framed by the central government.
Hmm.
Under the provisions of this.
Because two
Under provisions of section 15.
under this, no, you
Standing
kindly
order
see,
framed
no,
by-
see, this is being done. The standing orders are made under what provision?
Section 15,
Of
central model standing order of the act. Standing order act.
no, 15 is the rule.
Oh.
Section 15 is the rule.
Standing
Standing order is
yes,
12.
Yes, your lordship, because for the section 2G, if you will also read section 2G, it will be clarified. Section 2G probably, yes.
Means
Standing order means rules relating to the matters set out in the schedule.
Yeah.
So this rule was framed by both the government, state government as well as the central government. Now, so far this central government is concerned, initially when this rule was framed, then there was nothing about the adjournment.
so they inserted
They
it by the
inserted in the year in 1983.
1983, but
Eighty-
this has not been done by the center state. State have not done that.
Hmm.
State have made
Yes,
some
yes, the state
certain amendments to the 1947 rules by or has come up with a draft rules of 1985
Then 2005.
or 2005. Now that 2005 rules have not yet been given implemented. So as of now, you don't have the age or
There is
that
nothing
has
in the-
not been inserted. The schedule to the act has not been amended insofar as the state of Assam is concerned.
Yes. Now my submission subject to what your Lord view is that when there is no such rule or near such provisions, the provisions of the central legislation will be applicable if it is a subject matter of the content. If we go to the provisions of Article 245 as well as the 246, then it will be like.
So you mean to say when the power has been given to both the state as well as the center,
Yes, correct.
and the center have already
Exercise their power.
specified in their rules or by exercising that power.
Yes.
And the state having not done so,
Yes.
the central rules will take
Maybe.
over. In view of that, you are saying under 246.
Yes, yes. Is my something.
You have anything to support that?
Well, what the Lord's query is that whether the rule made by the central government, not the act, whether the rule.
Because if we
There's
say
two
that,
aspects. One is act, and other is the rule framed under the act.
no, because what you are saying, if we apply that principle out here, then the state, in view of their particular circumstances, the power has been given to the state as well as the center. Now the state, in view of their special circumstances, forget about the age, thinks that for our factories or industries, we don't require this age of retirement or anything. But the center feels that it is required for their own industries or factories. Then by dint of your submission, that provision will be attracted. It will have a serious consequences if we are
Yes,
going to attack.
Yes, if I,
The
Fine.
federal
There is a-
structure of
may
the
create a serious
constitution will be
consequences.
violated.
because for that reason, I will go through, I checked it up yesterday. Section 15, subsection 2. Because when this rule is framed by the central government, this rule has to be placed before the parliament.
Yes.
And if the parliament agrees with that rule, then and until this rule will be, will come into force.
Hmm.
So this rule has a force of act.
Maybe, but it
So
will
if it
only,
is a force of act,
but if we see the rule, it only applies to the union territories as well as the central government undertaking, not to anything else. It may have a
they
force of
kept
act.
it open for the state government to
It
frame.
may have the force of an act. It may be a rule which may be a statutory rule having the force of an act, but then also it can't be made applicable to the state because the state has been given a power. The state has
Yeah,
its
so
own
long
rules.
the state does
The
not.
state has its own model orders. So you say that the model orders which have been there, which is applicable in Schedule 1, mentioned in Schedule 1B, should be made applicable to the state. Will have a far-reaching consequences.
No, state can exercise their power.
Mr. Dasgupta, let me first listen as to why he says that it is 58. Yes, why do you say it to be 58?
Well,
Just on a hunch?
The 58 will solve my purpose, no problem.
Now, why does he say? Because he, on the other hand, while replying to the query number 3, said that the central rules or the standing orders of the center shall not apply.
Applied. That
Now,
is-
what is the basis on which he says in paragraph number 4 that 58.8 is the 8?
Well, referring to the draft rules, it is of 2005. We have said so far. Well, just before that, well, since Lordship is that as regard the discussions, the queries made to the petitioner, well, this particular company, they are having a standing order for workmen at page 82. And this particular order, there are two provisions I'm just indicating. This, it says that the order shall come into force on the expiry of 30 days from the date of certification of the same by the appropriate authority. That has been, certificate has been given on 7th of February 2008. And that particular, it says, clause 3 amendment, the mill may from time to time amend these orders in accordance with the provisions of the Industrial Employment Standing Order Act 1946. This 46, just now, Malab, the petitioners is referring, this 46 Act is applicable for the industries controlled by the central government.
No. The 46 Act is applicable to both the state as well as the center.
Central government.
There's no quarrel with that proposition. Section 15 empowers both the state as well as the center
Central.
to frame rules. Now, what happens if do you have that 46 Act?
Yes, Malab, 46 Act.
Open it.
I have
Yeah. The schedule.
schedule. Yes, Malab.
Now, the schedule prescribe that these are the things which are to be inserted in the standing order.
Yes,
Now, amongst them, the last of it is any other conditions which may be prescribed.
Malab. Any
Okay.
other?
Now, what has happened in 1983? The central government made their rules in the year 1946. You made the rules in the year 1947.
Lordship.
At that time, there was no prescription.
Prescription number 8. Yes.
The central government, in their rules, made an amendment in 1983
Logic.
and made a prescription that the age of retirement, and thereby, on the basis thereof, the schedule to the Act of 46 got amended.
Logic.
That is that.
Logic.
But the state has not done that.
But
Although you had a amendment in 1983,
Logic.
but you did not do.
Logic. Well, in the 83 amendment, it was not there, but a draft rule has been prepared by the
Forget about
state.
the draft rules. You only say that rules have not come into force.
Correct.
So we are not concerned with that. We can't take it. A draft rule which has not come into force is non-existent for us. So you have not done.
Malab.
Now, what has happened? The central government, in their rules, have a schedule. That is Schedule 1B.
Right.
In the Schedule 1B, there is a model standing order. There is a particular clause saying the age of retirement to be 58. Now, the case of the petitioners herein is if by virtue of Article 246, 254, and as this falls under entry 24 of list 3 of the 7th schedule, if not something is not contained in the rules of Assam by the government of Assam or in the model standing orders of the government of Assam, the rules of the rules of the central government or the model standing orders of the central government shall be made applicable insofar it is not inconsistent with the model rules of the state government. Now, my question is, let us assume that what he said is correct. Now here is an interpretation of Article 246 read with 254. Now what will happen if we assume that in a particular state, just for example, the state of Assam, they may not like to put the age of retirement. Okay? They may not like to put the hours of retirement. Intentionally, it may be. That power has not been exercised under Rule 15, to Section 15. So if they have not done so, and the rules of the central government categorically mention that it shall only be applicable to union territory or the central government establishment, can you bring the rules as regards the central government or the standing orders so far it is not inconsistent with the state government model rules for conduct, standing order, and substitute? That is what is the case of the petitioner's case. Now, I am asking you a simple. I have raised 3 queries.
Malad.
The first query is what is the age in absence of understanding of. You say that whatever may be, 58. What is your base?
Malad,
Number 2,
Logic.
I had asked, have you implemented or brought into force the 2005 amendment?
no,
You said no.
as on today, it is not.
Now, the third question I have asked specifically that whether the model rules of the central government shall apply, insofar it is not inconsistent, you said no.
No.
So, therefore, the main query remains is one, what is your basis to come to 50? Because that is the far-reaching consequences everywhere.
But our submission that the age retirement age may be considered as 58. It is on the basis of the draft rules. Malad, because in the draft we have
No, you can't do that.
in the draft Malad, we have proposed that the 58
Propose of what? But if the draft rules,
it has not come into force.
if it is
Correct.
not coming to
Correct.
force, then
Correct.
how can you say it to
Correct.
be 58?
Malad, if Lordship kindly allows me, what is in our mind? Malad? What is the authority? What is the in the mind of the authority? Malad? I'm just reading paragraph 3, Malad.
Hmm.
Paragraph 3 of the FAQ. Before answering the specific queries raised by the Honorable Court by order dated 22/6/2023 and 10/8/2023 passed in WPC number 880 of 2011, the following are the considerations. Malad. On examination of the provisions of the Industrial Establishment Employment Standing Order Act 1946 and the Industrial Establishment Standing Order Central Rules 1946, it is found that by virtue of Section 15 read with Section 2B and 2G of the Aforesaid Act, the rules framed by the central government applies in respect of industrial establishment under the control of the central government or railway administration or any major port, mine, oil field situated in this state or union territory. As per Rule 1(2) of the aforesaid rules, this set of rules shall extend to all union territory and shall also apply to any state, to industrial establishment under the control of the central government for railway administration or in the major port, mines, oil field. Further, there being no provision in the Act of 1946 providing that central rules shall apply in respect of industrial establishments not falling under the control of the central government in absence of rules framed by the state government. So for the industrial establishment under the state government are concerned, Section 15 of the Act empowers the state government bring the appropriate government to frame rules including on model standing orders. In the state of Assam, we have notified the Assam Industrial Employment Standing Order Rules 1946 of 1947, and there being no provision regulating the age of retirement. Well, this 47 standing order, 2 amendments already made in 67 and 83, but age of retirement was not there. And
Neither there was a corresponding amendment brought in thereby to amend the schedule. Interestingly.
in fact, in the 2005 amendment, the draft, it is proposed.
No,
This-
I'm not on
Lodge.
2005.
Lodge.
But those amendments which were done in 83 and 67
Lodge.
does not have a corresponding amendment which is there in the central rules under Rule 2A.
Correct.
Yes, then.
And there being no provision regulating the age of retirement, the draft Assam Industrial Employment Standing Order Amendment Rules 2005 has been framed, incorporating inter alia the provisions of retirement age of 58 years. The provisions of the draft rules prepared by the department is completely in consonance with the provisions of the central rules, insofar as the age of retirement is concerned. Although the said rule is still at the draft stage, government is considering to initiate the process for finalization of the rule. And at the earliest possible, the said rule may be in consonance with the provisions of the central rules, may be followed in absence of any certified standing orders regulating the age of retirement in any industrial establishment.
This line is
subject to-
very, the said rules being in consonance with the year may be
Lodge.
followed in absence of any certified standing orders regulating the age of retirement.
Retirement
In
in
What is
any
this?
industrial establishment. That
No,
we-
what do you mean by this line?
we are talking about the draft, because the spirit of the draft, we said that in absence of these rules, but we said that the said rules, that is the draft amendment, my lord, being in consonance with the provisions of the central rules, may be followed in absence of the certified standing orders regulating the age of retirement in any industrial establishment, subject to final order, directions of this honorable court.
So under such circumstances, you are saying
Lord.
that without a power which have been conferred upon the state government
Lord.
to fix, to make amendment to the rules, to the act, the schedule to the act, and thereupon to frame rules on that should be taken over by this court. It's what you are saying. It has a far-reaching consequences. This line has a serious consequence.
My lord,
You are saying that the draft rule, the rule-making power is absolutely yours.
with the state. With it,
You say that the draft rules have not come into being.
Lord.
You say that the draft rules is in consonance with the central rule.
Lord,
And as such, I should direct that 58 years should be the age.
But it is in our mind that since the draft, the intention of the state government, the rule making authority is,
Can there be an intention?
no, it is, well, in fact, since it is
You
not,
ought to have amended it, but
Correct.
why you were sleeping from 2005,
well, it
18
is,
years?
lordship, well, it is, they are taking steps to finalize the,
Understood, but
Draft
it has
agreement.
not happened unless this court has taken up this issue.
Correct.
Hmm.
now it is under process, my lord. It is, they have said that they are processing it, and at the earliest possible, they are doing it.
Now, what to do as regards this case, where the petitioners this held that these workmen have already superannuated at the age of 50.
Correct.
Now, what to do?
But here the issue arose,
That
because
is the issue.
because one is 72
Here there was
years,
none.
other is
There was
68 years according to them.
Huh?
Here the issue arose because ultimately in the award, the authority while passing the award says it is somebody has been allowed to work till 72 years. So 72 years will be the retirement.
Forget about the award, but the reason why these people were, the services were dispensed with or terminated or what you mean, is on account of they having attained 58. They've done that. And as such, if a person attains the age of retirement, although they don't have it in the standing order,
No.
although the person has attained the retirement, then the question about disciplinary proceedings or anything does not arise. Now, the Learned Labor Court held that you look here, why no? There's no standing orders to that effect. Then on what basis have you arrived that it is 58 years? Now, the government stand is
Look.
that this court should hold it as per the draft rules. Tomorrow I may be the headline in live law. Huh?
No, Malad, considering this peculiar situation, sir, since the state
No,
has.
no, it is not a peculiar situation. It is a situation made by you.
No,
You have
I
made
am-
this situation.
Yeah, because the
You
draft-
have slept over the matter. The central government has come up with the rules. Why haven't you done that? The central government of late have come into it.
Correct.
Maybe because of the fact that this was done in 1983. At that point of time, 58 was an age by which a person could not. Now the 58 would not be an age. Maybe. And as such, it was therefore necessary to make it the age of retirement. A 58 years in 1983 was a very old man. Nowadays, 58 is too young. So under such circumstances, now you have the central government thought about it. You also thought about it in 2005, but it's a labor matter. Leave it. Why should we take into action?
I must, that particular affairs of keeping the rule for last
18 years.
18 years. It's, I must accept that.
No, what to do now? Tell me.
No,
But
but in
what
a-
you have stated in paragraph number 3, the last portion,
Again,
that's very difficult.
no, again,
And it would be, you are asking this court should usurp the jurisdiction of the state government.
no, the view of the state is that only, my lord, in paragraph 6 also we have reiterated, because the honorable court has put the query. In response to the third query, we have again said, my lord, kindly para
No,
six-
you say that,
para
that
six-
the central rules shall not apply.
central rule would not apply because it is for the central.
So you say that, no, that is why I am
Mother.
telling you.
Mother.
You are asking this court to usurp upon your jurisdiction. Your jurisdiction is to frame the rules. Your jurisdiction is to have an age of retirement, which is also a condition of service as is required under Article 42 and 43. Then can this court do so?
Well, as such, directly, my lord, the industrial employment standing central rules 1946 would not prevail. And since, my lord, the draft has been prepared and it is in the mind of the state authorities that 58 has to be the retirement age. That is why, my lord, we said that.
But
it is not in
anyways,
consonance.
if I hold it also today,
Sir.
has to be prospective.
It will be prospective.
If I hold it prospective, then what happens in respect to a industrial undertaking? Because this is a matter of 2011. The person must have retired long time back.
2009, my lord, they have been terminated.
So 2009, no, this petition is of
Of
2011.
Of 11.
So
I have relaxed the judgment of Karnataka. The Karnataka High Court repealed Karnataka government NSD retirement age of
what happened out
worker
here?
from 58 to 60.
Hmm.
One company, the High Court upheld the
Kindly come here.
Yeah.
We can't hear you. Yes, what has happened? Which paragraph you are referring?
Karnataka High Court, Karnataka government enhanced the retirement age of the industrial worker from 58 to 60 years by amending
58 to 60.
58 to 60, by amending the rules. Then this one company, they challenged before the Karnataka High Court. And Karnataka High Court single judge rejected that petition and uphold the decision of the government, Karnataka government. Then again, retrial was there. In the retrial also, the High Court uphold the decision of the
Then
In our, in our state also,
No, what are you referring to, this judgment?
is that the retirement should be not less than 60 years.
Huh?
Retirement should be 60 years.
Should be
Retirement
60.
age. which-
Retirement age should be 60.
Because
That's a plea or an argument or a submission.
it must submit.
Huh?
It is not submission.
So what basis is what?
Basis is that already that it was the 1958 proposal was in 2005, already about 20 years back. Now,
No,
the-
now we are not concerned. We are not concerned now. Whether it should be 60, that is absolutely the wisdom of the state. This court can't do that. That is what I'm have been asking Mr. Nath. That look here, this court cannot fix the age. It is absolutely the wisdom of the state or the standing orders to frame, or they may have them terms and conditions. That is absolutely on your part. But I can't say that it should be 60 or 75 or whatever maybe. That is not my business. That's court's business. There might be some judgments, Mr. Nath. By which the draft rules or anything which have been, that some decision be taken can be, in absence of the finality being approached by the state and taking into account the pressing issue, the court adopts the draft rules. There might be some judgment. That is the only way out.
Top promotion rules.
Pressing age of retirement has become very relevant. You see, the court can do it in this manner. That the age of retirement is a very relevant aspect, conditions of service, which was not there then, or there was no amendment which have been made in terms with the central rules, as have been done in the central. Now, the issue arose out here, and it's not known whether there is any other issue, but they arose out here and this has come before this court. At the time when they were terminated in 2009, the draft rules were there.
Yeah, prior to 1983, when the retirement age was not incorporated, there were a number of cases.
Hmm.
What would be the retirement age?
Yes, then
Then in those cases, the court adopted a policy of industry come region and another is region coming. One of such judgment that,
show me that. That is the only way
that
something
can be
can
done.
help you.
Industry come region and then region come industry.
What is that concept? Industry come region and region come industry.
In a particular industry, in a particular region, industry located in a particular region, what is the age? What is the age of retirement of other industry? That is called industry come region.
So the other industries then, if we apply that, that will be the other industries of the state.
Oh.
Then in that regard, applying that, we can apply the rules.
Yes.
That is the way out.
There are number of
If
cases.
we can get there,
Hmm.
that judgment would support that.
Yes, yes.
Then
number of
this
cases.
can be, that is the only way I see a solution.
Well,
that
one case,
If the similar industries of the central government would
Yes.
be having the retirement of 58, that is how you can apply the
was applied, exactly.
idea behind the central rules,
Yes.
not
That
the
was-
central rules.
That was exactly applied.
Show me that.
Honorable Justice,
Where is that?
Gajendra Gatkar judgment. Of the
We have to now go back to 1965. 65?
65, 57, 59, those are the judgments.
Yeah.
Because on those judgments, these principles was up.
You give me that, we'll hear again, Mr. Nath,
No.
this aspect, because these are the very far-reaching consequences.
Sure.
Now, therefore, what Mr. Dasgupta is submitting is prior to 83, the central government also had this problem.
Sure.
And there were many cases.
Mm.
And what was done by the Supreme Court in those judgments, they have applied a principle of industry to and the region. Industry, relevant industries to that particular region. If that is the principle, I have not seen the judgment.
I can pass one day.
Yes. If that is the principle, then we can apply that in respect to some same industry of that period, the central government undertake could have the aid of. That is the only way by which it can be molded.
To some extent, Malad, under what conditions draft can be followed? Because the draft rule, it is not a
Draft
And
rules very
here,
difficult.
Another point that I would like to argue for your lordship,
Mm.
there are certain acts
Sure.
which are applicable for the industry. Say, for example, I have forgotten, I thought it was payment of gratuity act, not payment of gratuity. It might be Employees Provident Fund Act,
Mm.
when it is stated that if there is nothing mentioned about the retirement age, the retirement age should be 58.
That is in respect to that age act.
That act, yes.
But
That is
here,
time that I have
no,
not pressed.
no, unless you are applying, this can only would have been possible that that principle could have only been incorporated out here, provided
Provident Fund-
it is a clause out there in the General Clauses Act.
Hmm.
If it is there in the General Clauses Act, this can be done.
must have
Then
been. I could not-
for
I could
that
not-
one
yes,
needs
sir.
to look into the General Clauses Act. Otherwise, if it is in just for example in payment of gratuity or any other
Employees
payment of
Provident Fund
bonus act and all this thing, then that is specific to that act.
Yes, yes. For the purpose of that act.
Yes, which paragraph you are referring to? Para 70. It is significant that though the respondents have made their specific allegation that the appellant did not suggest that there was any age of retirement in force before framing of the standing up, the appellant put in a general denial of all the allegations. Obvious that though the appellant No, here one thing has happened where the age was not fixed.
Yes.
That period, they have made it 60. But the period where the age was fixed was 55. So all future entrance was made 55. But as regards the earlier period, it was say 60.
There were some cases where. the
No, where is
judgment
that? No, where are you mentioning about how the reason come so and so?
Yes, I will give it. to you. Right. At two, I can.
Okay. We'll hear
Regional-
it
regional
again when.
industry Policy is a recognized policy.
No, recognized concept, but this judgment goes against you. And what was the reference? Reference was what?
Reference was whether the termination was illegal.
The reference was not properly framed.
160.
It is a reference was whether the management is justified in terminating it.
In fact, the reference was taken as if that it was a termination.
So for the purpose of appreciation of the reference, there one case, there is Delhi cloth mills case, the pleadings of the respective case may kindly be looked. And these honorable could also pass an order in my case. This honorable Justice Gogoi's order, but yeah, that wherein these judgments are referred. Yes, I have brought. I'm giving. 2008, 12, SSC, page 275.
What is it?
I'm reading this paragraph.
You are a big company, you should be getting this data. All this photocopies, make all this compilation and give it to this court. Mr. Prasad, this is unbecoming of a petitioner which is a corporate.
Not corporate,
Absolutely, it's a corporate.
it's not.
And the company is a corporate. Isn't it a company for whom you are representing? Then I would have understood Mr. Das saying he's a workman. Corporate don't work like this. When I was a lawyer, I was used to appear for the corporate. We never used to work like this. Corporates should always be there with all judgments, everything, compilations, everything. Not in a manner. Isn't it, Mr. Das? Mr. Dasgupta has been also appearing for a lot of workmen, so I would not blame him. But Mr. Prasad keeps on appearing for a lot of corporates, so he should be knowing it. Isn't it? Okay, when can you help this court further in this point? This industries and reasons, this aspect may be the only way out. Else we have to hold it to be bad, uphold the labor court's judgment. If there is no age out there, we can't bring in the draft unless that industry reason thing can be brought in by way of the central government having the same things for similar industries. That is the only way out. Because it is actually the duty of the labor court which should have. And the court and the government also had made the reference wrongly because they didn't terminate them. They dispensed with their service, taking into account that they have attained the age of 58.
But notices were given because
I'm just reading this Delhi cloth milk case. In our opinion, the tribal may pass it to your office. And tomorrow or the after one, I will give the complaint. Paragraph 24.
Yes, where is the termination? Most respectively, I beg to today morning when I went to join my duty, the gatekeeper did not allow me to join when I questioned as to why I cannot, he replied, the manager is instructed not to allow me. As the result, I was not joining. I was working in the year and the date of the establishment. After working for so many, how my service could be terminated. Now, where is the termination?
67,
Page
page 67.
67.
This is the notice.
67. These statements are no longer required by the management as you are released from present with effect with immediate over it. And these are the two. About the third one,
The third
You
one
are
is,
sleeping on duty. You are sleeping on duty.
but
And
that
yet
is
I
a
admitted it.
that has been rightly set aside.
is
And now he's working.
Is what?
So we are not concerned with those third one.
That is not very serious one. Because the age is very serious.
No, this is the age only the concern, but other the third one, he should be getting all the benefits. Because there, without an inquiry, whatever sleeping on duty, you can't do that. That is no problem. So we
He has
will
admitted.
Hmm?
He admitted this.
So
Because
what?
we have taken back.
admit, Mr. Dasgupta, these industries, we know it, how they work. Admission is, this admission is no. admission.
Paragraph 24 probably, but I have taken it. Just
In our opinion, tribunal must in any event look to the pleadings of the parties to look up the exact nature of the dispute, because in most cases the order is so quickly that it is impossible. In this case, the order of the
very lot of it.
Okay, but the issue actually was because the order which was being given, the notice, overreach. So the reference ought to have been in this manner as to whether this petition, these persons were dispensed with the service on account of overreach, could have been.
Yes.
That should have been the
at
reference.
the time of termination, this notice was not issued. Just subsequent,
There is no termination also given.
there is no termination. Yes.
They say that overage don't enter.
Actually, this notice was during pendency, they prepared this. Notice.
Well, the
That
recourse,
is,
Lordship, there are decisions that recourse to draft service rule is permissible. Only for the interim to meet the emergent situation that is there. People, I'll examine that. But if the intention was not to enforce or notify the rules at all,
Because the problem arises now. You have not done for 18 years.
but,
It is only now you are actively, because of this filing of the this matter being taken up by this court.
Yes, yes. It is
But they
due
have
to
said
your lordship and effect. and nothing
Otherwise,
else.
no.
but the intention of the government is clear that
When did you start? Tell me. When did they start?
now they said that
It is when this court had issued. In fact, Mr. Nath, the Labor Department was not concerned prior to that also. You see the first affidavit filed by this joint secretary. Surprisingly, he doesn't know head or tail about anything. He has filed this. So, list the matter again on 29th. No, this is 2011 matter. We have to finish it on 29th. For further hearing.
only but the accommodation for 5-10 minutes, half an hour.
This is item 1.
Look.
2011 matter.
Is the HPC has gone to liquidation matter. He said he will edit it before the HPC, before the liquidator, if anything he gets matter. Otherwise, the office is not there. And the criminal case which was also pending, probably he got sentenced and convicted. But matter. Otherwise, matter, the case is picture matter that there was some altercation, there some senior officer, he assaulted senior officer also assaulted the matter.
Who is appearing for HPC in one? What is the status of the liquidation process?
He doesn't know much, according to the petitioner, my lord. He said, my lord, it is still under process, but initially,
Hmm.
that is his part. Some of the person who are being enlisted for
I
providing,
think
providing financial benefit.
the CRP has been what is that CRP full pay? IPC. The resolution plan has been, I think, approved out here for HPC. Because that day there was some matter when Mrs. M. Hazurika was appearing. She appears for HPC. So she submitted that now, that was a first appeal so filed by HPC. So she said that now nothing can be done, taking into account. You do one thing, there is only one way out is to withdraw and liberty being given to you to approach the resolution professional. That is the only way. Otherwise, there is a moratorium.
Yes, yes, moratorium.
Yes, your name?
Yes, my name is A. Chaudhary.
Hmm?
My name is A. Chaudhary.
Mr. A. Chaudhary, the learned counsel appearing on behalf of the petitioner submits. That taking into account the Nagaon paper mill of the Hindustan Paper Corporation, taking into account that the Hindustan Paper Corporation Limited is presently in the process of being liquidated. Now is undergoing a corporate insolvency process, resolution process. The petitioner would not like to press the instant petition. More so, as the petitioner have already attained the age of superannuation as on today. The claims of the petitioner, the Learned Council submits that the claims of the petitioner on account of the wrongful termination could be agitated before the appropriate forum wherein the corporate insolvency process is undergoing. Taking into account the above submission, the instant writ petition stands closed and the petitioner is given the liberty to approach the appropriate forum, if so permissible under law.
All right.
Hi.
Right, Mr. Lordship. In this case, my lord, we are led by Miss P. Bhuya, my lord. She is on legs, my lord, court number 1.
So
Madam,
you start,
My lord, madam, may we kindly pass over the time being, my lord.
this is what regarding what? He's working in the establishment of the respondent as a meter reader from 2007. His appointment is on daily basis. His grievance is that because of his age bar and lack of experience only by few months, he is not in a position to participate in the selection process in terms with the advertisement dated to
My lord, only time being, my lord.
the advertisement by offering his candidature and he may be allowed to participate. However, the results should not be declared. Now, what has happened?
Lordship, he was allowed to participate pursuant to an interim order passed by this court. And selection process is incomplete. He is not been successful.
Nothing
My lord,
remains.
She is on the way, my lord. Take my senior.
Make no
We have filed it on affidavit.
Wait. Then nothing remains.
My
You have
lord,
not been selected.
my lord,
Only grievance was that because of a few months here or there, you were not allowed to participate on account of age bar.
Yes, on account of age bar.
So now nothing has happened.
My lord, only time being, my lord. She is on legs.
Oh.
Only time being, my lord. She will.
Hello, we'll take it as the next item. Time being means if the other matter falls, the time being is finished.
oblige.
File doesn't go from here. Yeah.
11.
Yeah,
May I please, Your Lordship?
Visha infrastructure.
Respondent
Is
for
the
a
order of
social policy
status
authority to
cooperating in
deny
respect to the contractual list the matter on which they. Yes, what is your case?
case Lordship.
Who is the other side?
Handicap Forest Department.
Forest.
Yes, sir.
Okay. Now what is it?
Case is that Lordship respondent social forestry issued a NIT on 11/1/2021. Issued NIT on 11/1/2021
Yes.
for settlement of certain plantation work. Accordingly, persons to tender Lordship, 8 persons participated. There is a government notification regarding accepting of tender that may kindly be looked into. That is that page NIT Lordship page 39.
Page
39.
yes. Tender document.
Yes. Second,
Eligible bidders
Division
for
Forest
following
Officer,
package of
Personal
work
Social Forestry
separately.
Division.
Details of area. What is this roadside plantation?
roadside, column number 2, Lordship,
Hmm.
roadside plantation avenue, median national highway. Then
Okay. Now you
then-
participated.
I participated. Total 8% participated. Tender subsequently settlement work going to be settled with respond number 7. Here is the condition Lordship. Notification page 46, Lordship, may kindly be take to page 46.
Hmm.
That is Government of Assam order the Governor Public Works Roadside Department PWD planning. That
Then?
notification here is the law. May I read, Lordship? regarding acceptance of.
No, no,
tender,
first of all,
5%.
no, miss. We'll listen to all this. How do you apply this notification to them?
That kindly be, next page, Lordship, Forest Department also issued similar type of notification.
Show me
49,
that. Where?
Page 49.
49. That is the two additional so and so. With reference to the
Limit of
survey, it is informed that some contractors are quoted unreasonably lower load as compared to estimated cost may impact the quality. Put higher rates which may create again, yes, then
Then Lordship, ultimately, Lordship, 8% participated, 6% quoted it below 5%. There is also below estimated amount, and 2% quoted it below 10%. The 7 quoted is below 10%. That was also below the estimated amount, and 1% 9.99. That was it. Tender committee Lordship forwarded the documents of the petitioner for acceptance, and all are responsive. All the tender, all 8 tender found, all are technically responsive.
out of eight were technically responsible.
Technically responsive, but while accepting financial bid,
So they had that within 5% or 10%.
10%, technically they all are. But while considering the financial bid, that stated that 2% not considered because they quoted 10%, with a 9.99, and 6 other 5 are found are as per notification that they found responsive evaluated tender. And accordingly, after considering the materials on record of the all the tenderers, forwarded the case of the petitioners before the higher court for approval. Here, Lordship, in this case, Lordship, find Lordship that NIT was issued on 11/1/2020,
Hmm.
and last date for submission was on 1/2/2020,
1, 2.
2021. Before that,
Date of submission, publishing,
that
pre-bid,
NIT page 39.
bid submission. 18/1/2021. End date is 1/2/2021.
Yes.
Then
Prior to the last date of submission, there by a corrigendum dated 5/2021, 2 conditions have been modified.
where?
That is Lordship, that corrigendum in the subsequent affidavit Lordship filed by that time I was not getting, and it was also in the record. Respondent
Where is the corrigendum?
corrigendum is dated Lordship, CFO filed affidavit Lordship.
Hmm.
Page 16, Lordship will find
Affidavit filed by respondent number 6.
6.
Okay. Where is the corrigendum?
Corrigendum page 16.
Page?
Page 16, Lordship.
Corrigendum. So this was given on 23/1/2021.
23, 21.
This is before the last date.
Before the last,
Okay, then
the 2 condition Lordship have been modified. Lordship will find column number 2. Please read serial number 7(1) of tender documents and the serial number 1A of part 1 tender document showing experience of bidder in plantation and nursery work to previous years. Their preferable criteria not met.
At
And
7 previous years as preferable criteria not mandatory.
mandatory.
So these 7 years was dispensed with.
This person,
Then
because the response 7 has no experience regarding the plantation. So How they are favoring the respond number 7 lot type.
No. Then what is there? What is the problem with the corrigendum?
That on the basis of horizontal lordship, accordingly, technical bid was opened on 6/2/2021.
Hmm.
And financial bid opened on 17/2/2020. Then tender committee lordship forward documents page 53,
Page
53,
53.
53 of my report.
53. Okay.
Your lordship, there are 25/2/2021. That are forwarded conservative forest lower term social forest circle work out.
So you have been held to be the lowest responsive bidder.
Yes, sir.
Then,
Then lordship, column number 3, may I read?
Huh?
Page 53. That the technical bid was open. Page 53.
page
53.
56.
53.
53. Yes. Hmm.
That the technical bid was open on 6/2/2021 and the comparative statement obtained from the net against the e-tender, which is enclosed as Annexure 4, and the minutes of the tender evolution committee enclosed as Annexure 4A, where it is observed that 8 numbers of tenders participated and all are bid.
Hmm.
The comparative credibility reflected in the CS of technical bid.
Hmm.
That after opening of technical bid, the financial bid has been opened from the net on dated 17/2/2021, and accordingly the CS against the financial bid obtained, which is enclosed in Annexure 5. In this respect, it is observed that 8 numbers of tenders offered the bid. The bidder under serial number 1, 2, 3, 5, 7, and 8 offered the rate of below 5% from the estimated cost. The tenderer under serial number 4 offered the rate below 10%, and tenderer under serial number 6 offered rate below 9%. In comparing the offered bid, it is pointed out that the government of Assam PWD department issued a notification number so dated 12/7/18, which is reiterated by the PCCF, and office by letter number so dated 27/2020, which may kindly be looked into. The copy of the letter enclosed and this paper kind onward action in paper the earliest. Next, page 55.
Then,
That column number 4, lordship, serial number 4 of that letter. That financial bid obtained from the net so and Annexure 5, which appears from the comparative statement, the tender under serial number 1, 2, 3, 5, 7, and 8 offered the equal rate as 2,43,08,066 below from the estimated cost, and tender under serial number 4 offered 10% below, whereas tender serial number 6 offered 9% below from the
it's the same thing.
same thing, lordship.
Then,
And then according to the CS forwarded before the authority. Then lordship will kindly say page 57.
Hmm.
Page 57.
then
It was issued
tended to
by
bring
the
to your
additional
attention.
principal chief conservator forest social
The
policy
result
Assam
shows
Panjabari.
that the tenders were kept
Two.
open from Iman to Iman. That is only 15 days. Is what it It means. Yes, then,
He made proposal.
so they are giving it to MS Mechanism
Macrometer
builders.
builder.
So you are against that.
What are the reasons they have forwarded? That as per notification, the reason has to be recorded regarding acceptance of 10 funds. Here is it accept, nothing else. Only favoritism to the response happened. Earlier the NIT was modified because he has no experience in this field, and accordingly on that basis subsequently was to be offered. certain communications have been made to the authority for giving the one.
So your thing is when it is the policy adopted on the basis of the PWD, that circular,
Yeah.
and not to reject others who have less than 10% than the estimated cost,
Loss.
and you have in fact acted upon them and have rejected the tenderers at serial number 4 and 6 on the basis thereof, then why are you giving to respond number 7?
Yes, Lordship, that there is a specific direction, the notification for accepting the 10% may below the estimate cost, the reason has to be recorded. In peculiar.
No, his is
circumstances,
below 10%.
below 10%.
The
but
the
here
bid is
the-
10% less than the estimate, meaning thereby it has to be rejected.
I'm not on that reject, but while offering the contract Lordship, the reason has to be recorded. Since the other eligible bidders are there, they offered 5%. As per notification Lordship, as Social Forestry Department Lordship page 49,
Yes.
page 50 Lordship,
Hmm. Yes.
with reference to subject advice, it is to inform you that some contractors are quoting unreasonably lower.
No, we are not. We are with 1, 2, and 3.
Sir.
Come to number 3.
Tenders beyond 10%, positive or negative for the approximate cost shall not be accepted.
So that is this letter which you have enclosed at
I
page
am on-
57
Yes.
says that the lowest bid is 10% less than the estimated rate. Is his bid, respondent number 7's bid, lower than 10%?
Lower than that.
So that is what.
Just cross,
So you, he's hit by number 3.
hit by number 2 Lordship.
Why?
The variation of the quoted price rate up to 10% positive or negative.
Up to 10%.
Yes.
So if it is between the range from 0.1 to 9.99,
Yes.
reasons are to be recorded. But it can be accepted for reasons.
So the-
But if it is less than 10 or more than 10, it has to be rejected. Isn't it? Number 3.
made it number 2.
What is it?
Number 3 Lordship, this
Ah.
correct Lordship is if it is above. The tenders beyond 10%.
That is beyond 10% means up and down. Therefore,
Okay.
anything if it is beyond 10%, meaning thereby 10.01.
Lordship.
If a person's rate is 10.01 minus or plus, has to be rejected. The
Yes.
question of giving reasons also does not arise.
Yes.
Now here it has been mentioned at page 57 that the respondent number 7's rate is less than the 10% is 10% less than the estimated rate. So you say that your case is that if it is more than 10%, it is you have to reject it. But if it is 10%, then you have to record reasons why you are giving it.
Yes. That is clause 2 of the forest department.
Yes.
The reason for.
Why you are giving it?
Shall be placed on record. No reason.
No, it's okay. Now got it.
Today I'll seek some accommodation.
No, it's okay.
I am not keeping well and this records will
It's
receive.
not keeping well.
I am not bit well.
There is another
No,
one.
madam, this record
Who-
also receive only in the evening, madam. I have to go. Lordship will just grant me
We'll
some
keep
1
the
day time,
record.
madam. And the other part, madam, the beneficiary is also there. Respondent number 7.
He?
Respondent number 7, the beneficiary, he is also there. Madam, today he is also unrepresented, madam.
Very well.
Just seek, madam, a day's time.
No, if he is not there, it is much better. We
No,
do
he's-
have another
he's-
person to
He is
record the
coming, madam. He is
submissions.
coming. Mr. Majumdar was there.
There,
I seek
he automatically people come when this
I
court
seek,
takes-
my lord, accommodation. Normally, I don't
No,
ask for,
there is
madam.
no accommodation.
I-
This
normally
matters
I don't
on
ask for,
Tuesdays,
my lord.
Thursdays are. We immediately stayed then. There's a stay?
Status quo is
Yes,
there, my
status
lord.
quo.
There's
No,
no stay
no,
order.
not to further proceed with the
Yes.
work.
No,
Yes.
That is the order because of you asking for recommendation, stay.
let,
You know, on this day, who was appearing? One Miss M. Kolita knew that this matter. It was at their behest, the
Yes,
matter has been fixed
I
today.
know that, my
Well,
lord, but
What is all
records,
these things?
records came, my lord.
So records came, the records, produce the records, that's
I
all.
have to
What
go through, my
else?
lord. These are very voluminous record and this, then the.
I'm only asking you one simple question. His case is very simple. You have your own circular
Yes, my
wherein it says that if you have up till 10%, then in that case, you have to record reasons.
There are reasons, my lord.
What are the reasons?
There are reasons, my lord. When the person offered at 10%, he was asked to explain why he is offering at 10. Then he gave an explanation of the affidavit of the private respondent, my lord, at page private respondent number 7.
That is,
Robo, apni koto mo matam nahi. Letter, my lord, he was asked to justify. It's a letter dated 19 to 21 of the respondent number 7, my lord.
Nineteen
221, my lord. On 18, my lord, 18 to he was asked, and 19 to he replies.
wait.
At
Affidavit by respondent number 7.
7, my lord.
Yes, where?
Lord, you will find it annexure A.
Yes.
It starts at page number 5, my lord.
Hmm.
It refers to a letter issued by the authorities asking the respondent to offer a plausible explanation as to why
Hmm.
he has offered this and how he can justify.
Yes. Tell me. With reference to the stated above, I have the honor to inform you that although we have quoted our rate against the year as 10% below, but we are confident to execute the work at our posted rate without any compromise. on quality of time. In this context, we would like to furnish the specification in support of. We have a huge rate of things in Now, where is the reasons recorded?
My lord, shall see at page 7.
Huh?
Page 7 of the affidavit, Lord.
No. Page 7 is your.
My lord.
Please refer to your online page. Now, where's the reasons?
My lord, I'm coming.
The reasons are to be recorded by you, not by them.
I will come to our affidavit. Affidavit filed by the DFO.
Where?
My lord, records would reveal this.
Who was tender number 4?
Pardon?
Who was tender number 4?
Number 7.
Also, my lord, let's see the difference of price.
No, we are not concerned with price. You yourself have come up with all these notifications. That is your fault. Now, this document, kindly come to here, the writ petition. This is a dated document of 25/2/2021, written by the Divisional Forest Officer. Here you have rejected 2 persons. 4 and 6. The tender number 4 is the respondent number 7. Tender number 6 is not a party before this court. Northeastern Agro Services, whose quoting ratio is minus 9.99%. And interestingly, this document you have sought from the respondent number 7 is a document dated 19/2/2021. Whereas the Divisional Forest Officer as well as the Conservator of Forest on 25/2/2021 says that you have rejected it.
Things changed at the headquarters because my
The
lord, there's
headquarters have something
No,
else.
reasons are recorded, my lord.
Understood. Did you ask the reasons from the other one?
My lord.
Did you ask the reason from the other one? The
Other-
number 6. Did you
Six
ask
was-
him?
6 was offering 5, my lord, because there was a
No. 6. You see, there were 2 tenderers who were rejected. And it has been mentioned by your officials
my lord.
on 25/2/2021, in spite of the letter written on 19/2/2021.
My lord.
Is it not filling up some gaps, Mr.
No,
Gogol?
my lord, still see that page 53 of that petition, my lords,
Ah,
and 53 follows to 54,
yes,
55, my lord.
Yes.
55, my lord, let's see, though it's projected that this respondent number 7 was a party out there, he was no, he was not a party there, my lord. Lordship will kindly see page 56.
yes.
This is some different
What?
package, my lord. Package number 2 will be like no.
What package is different? We are concerned with which package? Package number 2. Here it is. He has given his reply to package 1, 2, and 3 on 19/2/2021, where everywhere he has quoted minus 10%.
Yes.
Then, in spite of that, your officials have done it. There must be something wrong either with your higher authorities, the commissioner and secretary, with the conservator of forest.
Commissioner Secretary doesn't approve, my lord. It's a PCCF. There are reasons recorded there, my lord.
Where is the reason?
record is there, my lord. So that was a reason, my lord.
Let
I
me
could
see.
take it properly, my lord.
Okay, at 2 o'clock. Or we can have it after vacation, no problem. But let the status quo, no,
Status
there
quo
should
is
not be
all-
any further.
The status quo is there,
Construction.
my lord. Already there.
No, are you
Just-
saying, no, are you saying that there is no work done on the basis of this orders passed?
Work has been.
The work is going on?
Let it be taken up at 2. Let it be taken up.
Mr. Borbe, you are satisfied with the status quo order?
My lord,
Disposal is required, Lordship. Status quo is there, Lordship, but status quo is there.
So you are satisfied, why
But-
should I
No,
have an
Lordship, I am
urgency of
asking
this?
Because work,
Okay.
21.
It has been informed to this court that the records have been received by the counsel for the forest department only yesterday. And he has expressed difficulty in doing the matter. Accordingly, this is the matter again on 6th of November 2023. The interim order passed earlier shall continue.
As per
My
my
lord.
information, lordship, work is going. So lordship, the court date.
It is further made clear that any work so done shall be subject to the outcome of the writ petition,
That is always.
and the respondent number 7 cannot claim any equity on the basis of the work so done.
My lord, can it be on Tuesday?
It is further directed that no amount be released to the respondent number 7 till the next.
Oblige.
Timing item 5.
Please, your lordship.
Mm.
My lord, I have placed some similarly situated persons, my
First
lord.
and foremost, this person has already you have been rejected.
This is a different selection.
The decision is where? Not selected. Where is it? Mr. Pathak?
Lordship decision is in our affidavit, Your Lordship.
Ah.
It is at paragraph number, page number 4 of our affidavit, Your Lordship. The last paragraph at the bottom.
Para?
It's a part of subpara 3, the last paragraph at the bottom.
Your affidavit.
Our affidavit.
2, 3, 4, 5, 6, 7, and 8.
Yes, Your Lordship.
Para 3 is nothing. There is only para 3 is that with regard to the statements made in para 1, 2, and 3, your humble deponent has no comments to offer.
No, page number 4, Your Lordship.
Para,
Page number 4, subpara 3.
by the minutes of the meeting held on Iman, the
Yes, that
committee for
page.
recruitment of bill clerks and Iman, as mentioned above, was distributed in different. Subsequently, the court. Yes, what did you want to show?
My lord, that instruction I don't have, my lord. Senior me to do this case, my lord, but
No, your madam, what was your prayer? Let us see your prayer. Shall not be issued directing the respondents number 2 and 3 to allow the petitioner to sit in the recruitment process for recruitment of bill clerks and so and so by condoning the age and experience of the petitioner as outsourced so and so by accepting the application form as to why should not be issued to issue admit card in favor of the petitioner to sit in the so and so. So it is already done.
Yes.
So that is your prayer.
Yes.
You were allowed. You were not selected.
Yes.
Then what remains out here?
but my lord, my service, my lord, from 2011, my lord, I am been working there, my lord.
So that is a different aspect. If you have anything out there, you may ask for something else. But nothing survives with the prayer out
Yes.
here. The instant writ petition was filed by the petitioner, seeking a writ in the nature of mandamus, thereby directing the respondents to allow the petitioner to sit in the recruitment process for recruitment of bill clerks and meter readers in the Assam Power Distribution Company Limited by condoning the age and experience of the petitioner as outsourced meter reader by accepting the application form of the petitioner, as well as also for a direction upon the respondents to issue admit card in favor of the petitioner in order to sit in the written examination for recruitment of bill clerks and meter readers. This court, pursuant to the filing of the instant writ petition, issued notice on by an order dated 27/9/2011, and in the interim directed that the petitioner may and in an interim permitted the petition to respond to the advertisement by offering his candidature, and the respondents were directed to allow the petitioner to participate in the selection process. It was, however, observed that the results of the petitioner should not be declared without the leave of the court. Pursuant to the said order, the petitioner duly participated in the said selection process. Was allowed to participate in the said selection process, along with 61185 numbers of applicants. However, only 1336 applicants were called for viva voce and the computer proficiency test based on marks obtained in the written test, and 673 numbers of applicants were finally selected after due computer proficiency test and viva voce test. It has been stated in the affidavit filed by the respondents that the petitioner, even upon allowing stated in the affidavit that even after allowing the petitioner to participate in the said selection process, the petitioner could not succeed in the same. Taking into account that the entire petition, that the grievance of the petitioner was only to the effect that the petitioner may be allowed to participate in the said selection process, which was duly allowed, and the petitioner having not succeeded, and having been allowed, and which was duly allowed pursuant to interim orders being passed by this court, nothing survives in the instant writ petition. The non-selection of the petitioner, as was informed by the order dated on the basis of the affidavit dated 23/7/2012, is a separate cause of action which has nothing to do with the instant writ petition, for which the instant writ petition stands dismissed.
Well,
Please, Your Lord. In the morning, the mentioned time, my lord, I had made a prayer that I'll be
Hmm.
making it. At the mentioned time, I had made a prayer that I'll be making a prayer for adjournment. This is the reason why I'm making the.
may I pray one? My lord, last occasion, Lordship has heard this matter at length. The commission vendor matter, my lord, of the Guwahati railway station.
I remember
Yes.
you are given in the platform number 2,
Yes, yes,
and this was given out there to somebody else.
correct, my lord.
Mr. Muzumdar has been
Yes.
given in platform number 1.
Yes, I play.
And he says that he is giving a lot of revenue to the railways.
My lord, for that reason, may I show just one document, my lord?
No,
At page
no, Mr. Hazarika. Very good. Very good. Thing is that this court had directed them to produce the record as there is a very particular reason why this court. As to whether any notice was issued prior to the relocation
Yeah.
of the petition. And as to when the decision was so taken to relocate the petitioner to platform number 2 and 3 for platform number 1. This court further finds it relevant for the purpose of proper adjudication of the petition that the records pertaining to the issuance of tender dated 9/8/2021, as well as the decision-making process for relocating the petitioner from the platform number 1 to platform number 2 and 3 is also required to be looked at. List the matter on which state Mr. B. Sharma, the learned standing counsel for the railways, shall produce the records in connection thereof. He says the records are not available.
No, records are available, my lord.
Yes.
The reason is, my lord,
With
the-
respect to the writ petition, we would like to inform that I had asked for certain clarification regarding the records pertaining to issuance of funds. I'd like to inform you that the concern is of- like to request you to kindly update it, that it- Yeah. Then
this is the reason, my lord, the concerned official, my lord, divisional commissioner, office, divisional,
he's taken the
Commercial-
file with him.
my lord, he has been sent on training, my lord.
Understood? He has taken the file with him.
No, my lord.
Then
There is
there's nobody who is,
there's
has the file.
Someone has to, my lord, take the decision. There's no clerical staff cannot take the decision, and it's in Landing, my lord.
And there is no in charge.
My lord, he is the divisional in charge, my lord.
Hmm?
He is the divisional in charge, my lord.
Who is the divisional in charge?
divisional commercial manager?
Concerned
He is
divisional
on training
official.
since prior to the date on which your lordship had passed the order. That very day itself, after lordship had passed the order, I had spoken to him. He informed me that he is in Baroda undergoing training, my lord. He'll be coming back. So I'm praying for only 2 weeks accommodation.
My lord, I am concerned, my lord, because 2 years have been passed up since we had this petition, my lord. And there is a, because my agreement is only up to 25.
I can do you a favor. Because this court is inclined to grant.
Yes.
But if you have any difficulty out there, then I can do one thing. I can say not, the matter is very urgent, but not before me. List the better before any other court.
Not,
Then I think you may be,
not, not.
list the matter again on 14th of September,
Much.
Deeply obliged.
on which date Mr. B. Sharma shall obtain the records as as mentioned in the order dated 10/8/2023 without fail.
Right.
Further to that, the stand of the railways in that regard, in regard to the said instructions so sought for by the order dated 10/8/2023 be also brought on record by way of filing an additional affidavit. It is made clear that if the records are not produced on the next date, as well as the affidavit is not filed, this court shall draw presumption as regards the contents of the records,
My lord,
or as regards the non-availability of such contemporaneous records pertaining to the decision-making process.
deeply obliged.
Can I take back the letter or it would remain?
Take
card?
it.
Much.
Martin,
Yes, Mr. Gupta.
my lord.
What has happened? Award passed?
Award is passed, my lord, but has not been released because of non-payment of the arbitral fee.
So the lien has been exercised.
Yes,
So no award has been passed. The award has not been
yes,
passed. That means.
yes,
So this is done under 38 or 39?
my lord. 38, my lord.
38.
But my lord, the issue here is that, my lord, he has challenged the order passed by the London District Judge, whereby, my lord, the court below has extended the time limit under section 29A. And, my lord, the petitioners can.
Does the court have the power?
Yes, my lord. Court has the power.
No?
My lord,
Arbitration is
29A,
considered.
my lord,
This
This is the issue.
Can only have the power if either of the party has applied to that. As per
that is
section
not,
25.
that is not.
But nobody has applied it, Lord.
So how did the court do it by himself?
My lord, there was an application filed by the petitioner under section 14 for termination of the mandate of the
That
arbitrator.
is a different, but
While
there was
rejecting
no
that-
consent given for extension.
But, my lord, the original time period had already expired, and that is also
Let us see section 29.
29, my lord. A.
The award in a matter other than international shall be made by the arbitral tribunal within a period of 12 months from the date of completion of the proceedings under subsection 4 of section 23. When was the award, the proceedings going on?
It was going on for the
When was the arbitrator appointed?
My lord, he was appointed in the year 2017 under section 11 application.
Thereafter, the arbitrator was changed. The second arbitrator was appointed, Lord, from 5/2/2018.
The award in the matter of, if an award is made within period of 6 months from the date of enters that shall be entitled to receive. Parties may by consent extend the period specified in the subsection 1 for making award for a further period not exceeding 6 months.
No.
If the award is not made within the period specified under subsection 1 or the extended period under subsection, the mandate of the arbitrator shall terminate unless the court
No.
has either prior to or after expiry of the period, so to extend the period.
No.
Provided that while extending the period under subsection, if the court finds that proceedings have been delayed for reasons attributable to the arbitral tribunal, then it may order reduction of the price, provided further that the
Ending.
is
Commit-
pending, the mandate shall continue with the disposal of the state. Provided also that the arbitrator shall be given an opportunity of extension of the period of any of the parties.
That is, my lord, maybe. The word is maybe, my lord. And that is in addition to the earlier provision. It can also be. And here admittedly, there has been no application for extension.
Huh?
Lord, here there has been no application for extension. The period, the mandate had already expired. My lord, when he approached the London court, my lord, below under section 14, praying for termination of the mandate, my lord, at that point of time, the mandate of the arbitrator had already expired. My lord will take page
No,
2.
no, the power is however given, provided that while you see, if the award is not made within the period specified in subsection 1
Yes, ma'am.
or the extended period specified under subsection 3,
Yes.
the mandate of the arbitrator shall terminate unless the court has either prior to
My lord. Or
or
after expire.
after the expiry of the period so specified,
My lord.
extend the period.
Here, my lord, after the expiry, court has extended the period. When the application, my lord, for termination of the mandate under section 14 was filed, at that point of time, the mandate of the arbitrator had already terminated. The 12 months time and the 6 months time, my lord, had already expired. Both are independent provisions, my lord.
Because the word used is may. So my lord, the application for extension may be, but the power of the court is always there. My lord, I am supported by a recent judgment, my lord, of the Kerala High Court, my lord, very similar, my lord, which you have come up with.
Lordship, I have submitted a judgment on this point and Supreme Court judgment, para 22, Lordship.
Right.
Para 22 Supreme Court judgment, Lordship.
Where?
I have already submitted, Lordship. That NBP,
NBC.
NBCC, Lord, para 22, it clearly it is mentioned that without application, the court cannot do it.
Where is it mentioned?
Para 22, Lordship.
Not- Where is para 22? No. You are mentioning about NBCC.
Okay, then that must be some other, same name is there. That is there, Lordship. That is there.
Gupta?
My lord.
Dhiman, Lordship.
Huh?
Dhiman.
Remember, this is the judgment of the year 2010.
Right.
And at that point of time, there was no power to grant extension.
One more submission in
Yes.
related, Lordship. This,
That
we
is
have,
why it says the 1940 Act permitted, but 1996 Act did not permit the court to grant.
Lordship, one thing is there, one thing we have actually, the party has mistaken. Whatever this contract is pertains prior to the 2015 amendment. That means this is applicable. You say, Lordship, this is a contract of,
The arbitrator is appointed in
just
2017.
let me speak. This is contract of 2012 and 13. And that was this judgment must prevail. There was no question of raising of 29, Lordship.
No, that is why, Mr. Dhiman, I asked you a very specific question.
Lordship,
In my opinion,
Lordship.
this 29, section 29A was amended in the year 2019.
15, Lordship.
15, my lord.
15.
15 and 19 twice.
2015, 29A was brought in.
It was amended on 2016 with a retrospective effect, Lordship.
That's true.
Lordship.
So, till 2019, section 29A was holding the field
2000,
as it stood as per 2015.
prior to 15, Lordship. Prior to 15.
No.
But my case is prior to 15, Lordship. My contract is prior to 15.
It is not a contract. We are concerned with the arbitral proceeding.
Lordship.
Your arbitral proceedings first started in 2017.
2018. 17, like so.
Then there was a substitution.
Lordship.
It came in 2018.
Lordship.
So at that, your arbitral proceedings is a period from 2015 to 2019 between.
Lordship. Okay.
So whether there was a power to extend then,
5 is very clear. Without an application cannot be extended time, Lordship.
the
And
word
may doesn't,
may.
may stand for definite, not may stand for that.
What does the Kerala High Court say?
My lord, Kerala High Court, my lord, paragraph 11 and 12, my lord. Page 9 and 10. But court can extend arbitrator's mandate without parties' consent, my lord.
Here, interestingly, Mr. Gupta,
My lord.
this happened in 2021. The person was appointed in the year 2000, arbitrator was appointed in 2021. Whereas in his case, the arbitrator was appointed in 2007.
My lord.
So the reference to the entered into the reference in 2017.
But thereafter, my lord, there was a substitution,
That happened in 2018,
my lord.
but before 2019.
My lord.
You see, there is a difference out there. 2029A was amended. Prior to that, it was the award shall be made within a period of 12 months from the date the arbitral tribunal enters upon reference.
Ah.
The arbitral shall be deemed to have entered upon reference on the date on which the arbitrator or the arbitrators, as the case may be, has received notice in writing of their appointment. Then you see four was there. Then
Four
also
was there, my lord.
five was also there.
Yes, my lord.
The extension of the period referred to here may be on an application of any of the parties and may be granted only for sufficient cause. Now let us see what.
My lord, only the 29A first part was what, my lord, with effect from 38, 2019.
Huh? Well, you are referring to which clause?
Lord, I am referring to 29A4,
Para 11.
para 11 and 12, my lord.
Okay, read it.
My lord, section 29A1 provides that the awards in matters other than international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of pleadings under section 23(4). Subsection 3 of section 29A empowers the parties by consent to extend the period specified in subsection 1 for making the award by a further period not exceeding 6 months. Thereafter, if the award is not made within the period which is specified in subsection 1 or the extended period specified in subsection 3, the mandate of the arbitrator shall terminate unless the court has, in terms of subsection 4, extended the period either prior to or after the expiry of the period so specified. Thus, in a domestic arbitration, section 29A1 stipulates a mandatory period of 12 months for the arbitrator to render the arbitral award. However, the court is empowered to extend the period for making the award on application of any of the parties for sufficient cause. According to Shri Saji, the mandate of the arbitrator can be extended by the court under subsection 4 only in cases where the period for passing the arbitral award by the tribunal is extended for a period not exceeding 6 months by the parties by consent as provided under subsection 3. I cannot agree to this argument. Subsection 4 of section 29A deals with cases where the award is not made within a period of 12 months from the date of completion of the pleadings, and it provides that if the award is not made within period specified in subsection 1, the mandate of the arbitrator shall terminate unless the court has either prior to or after the expiry of the period so specified extended the period. The said subsection with the use of the conjunction or also applies in cases where the award is not made within the extended period not exceeding 6 months specified in subsection 3. It is not as if it applies only to cases where the period is extended under subsection 3. In the case at hand, the period of 12 months from the date of completion of the pleading within which the time arbitrator has to make an award is not extended by the parties by consent. Therefore, the mandate of the arbitrator stands terminated on the expiry of period of 12 months from the date of completion of the pleading. However, the subsection 4 provides that the court is empowered to extend the period for making the award either prior to or after the expiry of the said period. Subsection 5 provides that such extension of period may be on the application of any of the parties and may be granted only for
sufficient cause and on such terms and conditions as may be imposed by the court. So, my lord, here is a case, my lord, where the
Then the last line,
my lord.
subject to the above,
the
The
time
time limit
specified-
specified for a
can
year
be
can
extended.
be extended. Then where is it?
So, my lord, here the period of 12 months had already
How did
expired.
the court exercise the jurisdiction? Who asked him?
My lord, it was his application under
His
section 14.
application is for removal.
Yes.
But how did the court exercise the power to extend it? Understood.
My lord.
But it was nobody's case for extension.
Court, my lord, exercised its power because the mandate had terminated, my lord.
How can the court do that if nobody is asking?
Under 29A4, my lord,
But can the court on its own do it? Somebody
It
has to
can,
make
my
a
lord.
reference.
If in a situation, my lord, where the mandate is terminated, and also there has been no extension of 6 months.
His
by the
application was under 15,
14.
On 14 lordship.
14 for removal.
That is right, the lordship, when they have not filed an application under section 29, how the court exercise power, that is their lordship.
Failure or impossible. The mandate of an arbitrator shall terminate and he shall be substituted if he becomes de jure or de facto unable to perform his functions or for other reasons fails to act without undue delay. And he withdraws from his office or parties agree to the terminate. If a controversy remains concerning any of the grounds referred to in clause 1 of it, party may, unless otherwise agreed by the parties, apply to the court to decide on the termination of the matter. If under this section or subsection 3 of Iman, an arbitrator withdraws from the office, then he may do it. So his application was under 14.
My lord.
Then what was the business of the court to extend it?
So at the time when he made the application, the mandate had already expired. The
Therefore,
mandate had already expired.
nobody asked the court to extend it. Nobody asked.
My lord,
What
but
was the business of the court to extend it?
no, in my humble submission, court has power after the expiry of the mandate.
Are
Court
you
has
saying that
exercised
the
its
court
power.
has suo power to extend it? The court should keep on waiting out there. And whatever arbitral tribunal, whatever happens, then one fine morning the say, okay, do that matter. I'll extend it. Without an application. There is no
It was
business of
brought
the
to-
court.
The court has taken a judicial notice because the matter was before the court. Otherwise,
Court was for the judicial notice was that to terminate him.
that
is
could
the
not,
only-
that
but who is
termination,
the who? Why did the court extend it? Court had no business to extend. There was nobody. You see, an arbitration is a private tribunal between the parties. Section 5 says that the court should not interfere unless, because this is a very important mandate, which is not there in other clauses.
No.
Section 5 says that there should not be judicial intervention unless specifically mentioned in paragraph part 1. Isn't it? Let's read paragraph section 5.
subsection 5, the extension of the period.
Section 5.
Five.
This is a very important clause.
My lord, sir. My lord,
What does it say?
not,
See the wordings
my lord.
of section 5. This is a very relevant section because otherwise you don't have such clauses, sections out there. Notwithstanding anything contained in any other law for the time being enforced, in matters governed by this part, no judicial authority shall intervene except where so provided in the part. So when it is provided under section 29A to extend on the application of a party, the court couldn't have done it under section
My
5.
lord, my humble submission, my lord,
Hmm.
the power under 29(4) and the application for extension, they both are separate powers, my lord. That is what
How does the court, how do you read section 5 with 29(4) and 29(4)? Tell me.
because, my lord, the fact.
Because the court did not say
My lord.
that the court can suo motu do it. It is not given out. Then you read section 5. that unless the part one says specifically how to do it, you don't do it.
No.
Then how do you read that the court suo motu says, oh, he has filed this application, let me extend it. His application is gets automatically
My lord, in the
infractions.
Kerala High Court matter, my lord, which I have just now referred,
And I could, I am not bound by that.
my lord. My lord, here the situation was similar. Here, what has happened, my lord, the period of 12 months had
No,
expired.
did Kerala High Court take section 5? No. Kerala High Court never took section 5.
My lord, but the
So this
provisions
is a
of-
very important aspect because otherwise what will happen? You are making section 5 useless. This, if section 5 was not there, let us assume section 5 is not there in the books.
well, this
Now tell me, by virtue of that word may, you can very well say the court otherwise also have some powers.
No.
Some power, maybe, some power it can. But by virtue of section 5, you cannot.
my lord, that power,
You can't exercise power similar to 151, power similar to 482. You can't do that.
but my lord, the powers in the 29(4) is in a very special situation because it also deals with the situation where the period had already expired.
Absolutely. Even after the expiry, a person may very well, one of the party may go,
My lord,
look,
that
here,
power
look,
is not-
everything has happened,
My lord,
extend it. The court can extend it now also. As of now also.
Ma'am.
The period also, you can file an application for extension. And as of now also, the court can extend it by virtue of section 20. Because by way of an application, you can.
Ma'am.
But if there is no application, if you do it, how does the court do it in view of section 5? Difficult. Therefore, you see the subsequent provisions.
Okay.
Once it is substituted, you see there is a substitution. There are two substitutions. One is a termination
Okay.
under section 13.
Okay.
And section 29A says about substitution. And also further, if you see in 29A 6 or 7,
my lord.
it also goes to say that a person, arbitrator substituted by virtue of these provisions. That is section 29A. See this language. You see, 7. In the event of an arbitrator being appointed under this section, so this power is being exercised under 29A, which is parameterial to the powers out here while this power which is being otherwise to be exercised under section 11 for appointment of an arbitrator is also given to the court in circumstances under 29E.
Right.
Therefore, you see, provided further that where an application is pending the mandate here, provided that the arbitrator shall be given an opportunity of being heard before the fees is reduced. The extension of may be on the strength of while extending the period, it shall be open to the certain. If the award is not made within the provisions of the extended period, the mandate of the arbitrator shall terminate unless the court has prior to or after expiry post specified period so specified. Extend the period, provided that while extending, if the court finds that the proceedings have been denied for reason attributable to error, then in case of a reduction of 20%. The extension of period may be on an application of any of the parties and may be granted only for sufficient reason.
Oh, here is the situation about where there has
While
been
extending the period, it shall be open to the court to here, see, para 6, clause 6. While extending the period referred to in subsection 4, it shall be open to the court to substitute one or all of the arbitrators. And if one or all of the arbitrators shall continue from the state already reached and on the basis of the evidence and materials already on record, and the arbitrator appointed under this section shall be deemed to have received the said evidence and material. So
No.
this will be the court, while extending, can also substitute.
Yes. Well.
Otherwise, what happens? If you don't do it, now come to the judgment in McDowell, Burn standards. McDowell versus Burn. And this has been further followed up. Section 34 application. This is Rohington Nariman's judgment out there wherein it says a Lakshman Rekha. Meaning thereby the power is only there to set aside. The power is not there to modify. So an award being passed, that award can't be modified under section 34. The award can be only set aside. Now what happens thereafter? Does it go back to the arbitral tribunal? No. You have to go and appoint a fresh arbitrator. Because this is all because, again, come back to section 5. Because otherwise the part 1 does not say anything. What do you say?
Well, here is the situation, my lord, in a case, my lord, where the party has not applied for extension.
Yes.
Here
There might be,
admittedly-
because what happens? See the analogy and drawing the analogy from that section 34. It's set, arbitral tribunal award is set aside. And none of the parties then approach. What happens? Nothing. Here the mandate has been given to the arbitral tribunal. Look here, you have to do it within 12 months or from the date of the pleadings, or 6 months extended if the parties agree. Or the parties may file an application for extension, then the court will grant. If the parties tomorrow does not want, just take a situation where both the parties don't want that arbitrator. He's delaying it. Can the court on the own, and you file an application, just for example, you file, he takes 3 years. And every time he comes up, that arbitrator comes up and says that, okay, you give me this sitting piece. If both of you are fed up, then one fine day he said that no, nothing doing. We have got this chance on the 29A, let's remove him. So you file an application, let's remove him under 14, impossibility, de jure and all this. The court says, no. We extend further. Then the court do it. They'll have a serious consequences. Because it is a private tribunal between both of you. What do you say? Think it?
No.
2 o'clock? Anything else if you come? Let's be passed out.
No. Good.
Okay, let's see the facts. This is the order, and page 8.
Lordship, yes, sir.
Yes. Page 8 is
It
the
is
order.
eight order. It-
When did the 2019 Act come into being?
The amendment, my lord.
Yes.
My lord, it has come, my lord, on 38/2019. One more judgment, I will refer, my lord, the comparative distinction between the two amendments is made in one paragraph, my lord, maybe.
Tata Sons.
Yes, ma'am. Tata Sons.
And the application was filed in 2019.
Lordship,
You
report
filed the application for under section 15,
114 Lordship.
under section 14
That's,
in the year 2019. So this is before the
Uh,
COVID.
that was filed on, my lord, 21/8/2019.
So this is before the COVID.
Yes.
And the application was filed before the coming into effect of the new act,
My lord,
isn't it?
my
Yes,
lord.
sir.
So here we need not look into the 2019 amendment.
Yes.
2019 amendment otherwise has been stated to be procedural,
My lord.
even in the Tata Sons.
Yes.
Following this, the Sapuranji judgment of
My lord.
Delhi High Court.
My lord.
The last paragraph of the last but one page. Yes, the last. Yes. Isn't that?
My lord.
So there in that case, it has been mentioned to so. So that would, however, not apply, taking into account that his application under section 14 was prior to that.
My lord.
And the court surprisingly extended it for 1 year.
Yes. So that is the maximum power.
No, does the court have the power of extending to 1 year? That too
There is
after
no time
deciding
limit,
the
my lord.
same after 3 years. Application was filed in 2019.
My lord.
Decision is of the year 2022.
My lord. That is the maximum period under which.
Hmm?
That is the maximum period. Right? It cannot, court also cannot extend beyond the statutory period.
Now, can the
Because-
court extend beyond to 1 year? Wouldn't that violate the mandate of section 29(1)(a)(1),
Yes.
29(a)(1), which says the maximum period to be 12 months?
Yes.
Now, what has happened thereupon? The award was passed.
What?
But the award has not been published. So as of now, the arbitral proceeding still continues. Let's see section 33. Termination 32. The arbitral proceedings shall terminate by the final arbitral award or by an order of the arbitral tribunal under subsection 2. The arbitral tribunal shall issue an order for termination of the arbitral where the claimant withdraws his claim, the parties agree to an arbitration termination or finds that the continuation of the proceedings has or any other reason become imposed. Subject to subsection 33 and subsection 4 of the mandate of AR shall terminate with the termination of the arbitral proceeding. Now, the termination of the arbitral proceedings is on the basis of, can be on the basis of
Award money. And only when the final arbitral award is
see, the
Pass.
claimant withdraws his claim unless the respondent objects to the order and the arbitral recognizes the legitimate intent on his part in obtaining the final settlement of the event. Agree on the event, the arbitral finds the continuation or for any other reason has become impossible.
that is the other part. My lord, there are two parts. One is by way of final arbitral award and the other, my lord, under section
By
32.
the final arbitral
two.
award. Now, when would the final arbitral award be passed? 331, section 31.
31.
Form and contents. An arbitral award shall be made in writing and shall be signed by the members of the arbitral tribunal. Now kindly come to 31.7. 31.5. After the arbitral award is made, a signed copy shall be delivered to each party. The arbitral award may at any time during the arbitral proceedings make an interim term, unless otherwise agreed to the parties wherein insofar as the arbitral award is for payment of money may include such terms. Now, there is one judgment of the Supreme Court wherein it says the termination, the termination only happens when the arbitral award is delivered under 31.5. So as of now, as the arbitral award has not been delivered and the arbitrator is still holding the lien, isn't he holding the lien over it under 38? That lien. Yes. 39. Subject to the contrary to the provisions of the Iman, the arbitral tribunal shall have a lien on the arbitral award contract. If in any case the tribunal refuses to deliver its award except on the payment of costs demanded, the court may on an application in their behalf order that the tribunal shall deliver the arbitral award to the applicant on payment of the court by applicant and demanded so and so, and if anything is further ordered that out of the money. So as of now, the arbitral award has not been passed.
If my lord interface with this order, my lord, the present situation would be the mandate of the arbitrator would stand terminated because my lord on 3.
So this will be terminated under 29A2 or 3.
41.
Huh?
14.8. 14.8. 14.1.
No. This will stand terminated on terms with 21.
My lord 29A4, my lord.
29. If an award is not made within the period under one or extended period under the mandate of AR shall terminate unless the court has prior to or after the expiry so specified extended the period. So it will be terminated.
My lord.
It will only, the mandate will be terminated.
Yes.
So thereby, it will be left open for you or him to apply to the court
My lord.
for extension or for appointment of a bigger. The court may extend the period.
My lord.
You see what is happening. While extending the period referred to in subsection 4, number 6, it shall be open to the court to substitute one or all the arbitrators, and if one or all of the arbitrators are substituted, the arbiter shall continue in influence. So the court still granting an extension can also grant the substitution.
So that whatever the document is submitted that earlier arbitrated, that will be continued.
Yes.
Not fresh will going on that. Then we can apply for this on section 11 and a fresh arbitrated section 11.
Why do you have to apply under section 11? You can very well apply under 29.4,
That
29.6.
Red bit 29 Lordship. No?
No, why you are then, you
Direct-
see,
direct
then
29.
then it will be changing the jurisdiction.
Like-
If you go under 11, it will be before the Chief Justice.
But-
But if you do under 29A, you have to do it before the principal civil court.
that principal, well, this honorable court can do it. And under section 29, there's the appointment of arbitrator. substitute
No,
arbitrator.
here provide, this court could have done it if it is an appellate court.
And this court
This
can be
court-
done.
No, no,
Lordship.
this court can't do it. This court, there is no appeal against that order. So how can this court exercise the power under 29?
Then-
It has to be done by him. It is the court who can do it.
Then this designated.
Because you see, the appeal is only in respect to those which are given in 37.
37. Against 34 only.
Refusing to refer, granting or refusing, setting aside, appeal shall also lie under section 16. Refusing to grant an interim, no appeal shall lie against that one. So this court has no power.
It
So
means-
except setting aside, giving the liberty to the parties to approach seeking extension, it can be done. But this court can't set aside. Therefore, the instant application under Article 227 of the Constitution, 227
Lordship.
has been filed challenging the order dated 22/3/2022 passed in TS bracket ARB bracket close case number 1/2019, whereby the learned district judge Punitpur, Tezpur, while adjudicating an application under section 14 of the Arbitration and Conciliation Act 1996, for short, the Act of 1996, exercised the power under section 29A (29A4), capital A,
My
Cap-
lord,
of
capital,
the-
capital A.
of the Act of 1996, and thereby extended the time limit for publishing the award for a maximum period of by 1 year. That is from 22/3/2022 till 22/3/2023. The facts involved in the instant case is that certain dispute arose between the petitioner and the respondents. For which this court, in exercise of the powers under section 11 of the Act of 1996, appointed one Colonel retired Manoranjan Goswami as the sole arbitrator on
On 27, 2017.
27, 2017. Subsequent thereto, the said sole arbitrator resigned on held ground, for which this court, by an order dated 5/2/2018, appointed the performer respondent herein as the sole arbitrator. This court finds it relevant at this stage to observe that at that relevant point of time, Section 29A1 of the Act of 1996 stipulate that the award shall be made within a period of 12 months from the date the arbitral tribunal enters upon the reference. It is the case of the petitioner that the arbiter, that the learner, that the performance respondent hearing entered into reference on 5/2/2018, and in terms with Section 29A1 of the Act of 1996 was required to publish the award on 4/2/2019. It is also an admitted fact that both the parties agreed for extension of the period of the arbitral proceedings by 6 months, which is as per the mandate of Section 29A(3) of the Act of 1996. The said period expired on 3/8/2019. Thereupon, when did you file that application?
It was filed on 21/8/2019. 21.
Thereupon, on 21/8/2019, an application was filed by the petitioner before the learned district judge, Punitpur at Tejpur, under Section 14 of the Act of 1996 for termination of the mandate of the appointed sole arbitrator. At this stage, this court finds it relevant to observe that in view of the provisions of section 29A4, the said application was not necessary to be filed. Inasmuch as a reading of section 29A4 stipulates that if the award is not made within the period specified in subsection 1 or the extended period specified in subsection 3, the mandate of the arbitrator stands terminated by operation of law unless the court had either prior to or after the expiry of the period so specified extended the period. Be that as it may, the learned district judge, Punitpur Tejpur, by the judgment and order dated 22/3/2022, that is almost after 3 years, that is almost 3 years from the date of filing, disposed of the said application under section 14 of the Act of 1996 by rejecting the same. However, the learned district judge, by the impugned judgment and order, exercised the power under 29A4 of the Act of 1996 and extended the period, the time limit, by another 1 year. That is from 22/3/2022 till 22/3/2023 for publishing of the award, and with a further observation that in the event the arbitrator causes any further delay or attribute delay in publishing the award beyond the 1 year extended by the court, the fee of the arbitrator would be reduced by 5% for each month of such delay. It is against this order that the petitioner has approached this court under Article 227 of the Constitution. Next. The learned counsel appearing on behalf of the petitioner in person. The petitioner herein is a proprietorship firm belonging to Sri Gyancham Das Dhiman, who is present in person. The petitioner in person submitted that the learned district judge Hunipur could not have exercised the jurisdiction to extend the period in terms with section 29A4 of the Act of 1996, as neither of the parties had filed any application seeking extension. He further submitted that section 29A4, that the power that he further submitted that the power to grant extension by the court under section 29A4 can only be done on an application of any of the parties and that too for sufficient reasons and for such terms and conditions as may be imposed by the court. He further submitted that the perusal of the impugned order not only impugned order by which the time limit was extended not only suffers from lack of jurisdiction, but also goes against the very mandate and the legislative intent behind the enactment of, behind the incorporation of section 29A to the Act of 1996. Anything else? That's your submission? Mr. H. Gupta, the learned counsel appearing on behalf of the petition respondent. Though have fairly submitted that there was no application filed by either of the parties seeking extension of the time limit. But submitted that even without an application, the court has the power to extend the period, the time limit. He further submitted that the petitioner herein was responsible for the delay in the arbitral proceedings. Inasmuch as the petitioner had sought for various adjournments during the arbitral proceedings. It was also the submission of the learned counsel for the respondent that the respondent had also verbally fought for extension in terms with section 29A4 of the Act of 1996. Mr. Gupta, I am doing it on the basis of paragraph 14 of the judgment. Of your judgment, no? That impugned judgment, paragraph 14. This is what has been mentioned. Yes. The learned counsel for the respondent further submitted that on a conjoined reading of subsection 4 and subsection 5 of section 29A of the Act of 1996 would show that it is not only on an application filed by the parties, but the court has also the jurisdiction on its own to extend the period, to grant extension of the time limit. Anything else? I've heard the learned counsels for the parties and have also perused the materials on record. Taking into account that the application, taking into account that the period which was mutually agreed, period of 6 months, which was mutually agreed, had admittedly expired on 3/8/2019. And the application was filed on 21/8, no?
21/8/19.
21/8/2019. The provisions of section 29A of the Act of 1996 would be applicable as it existed prior to 30/8/2019, on which date Section 29A (1) and 29A and 1 and 29A4 was amended. Be that as it may, from a perusal of Section 29A1, it would be seen that the award was required, that the time limit for passing of the award was within a period of 12 months from the date the arbitral tribunal enters upon reference. In terms with subsection 2 of Section 29A, a period of in terms with subsection 3 of Section 29A, the parties may, by consent, extend the period specified in subsection 1 for making the award for a further period not exceeding 6 months. From the admitted facts, the period of 6 months elapsed on 3/8/2019.
Right.
Now coming to subsection 4 of Section 29A, it would be seen that the award, if the award is not made within the period specified in subsection 1 or the extended period specified in subsection 3 of Section 29A, the mandate of the arbitrator shall terminate by operation of law unless the court, that is the court in terms with Section 2 E of the Act of 1996 extends the period either prior to the expiry of 6 months, either prior to the expiry of the period mentioned in subsection 1 or subsection 3 of Section 29A of the Act of 1996, or after the expiry of the period so specified. The provisos to the said subsection 4 of Section 29A is, however, not applicable to the instant case, as it relates to reduction of the fees of the arbitrator for any delay so caused, semicolon. It relates to the mandate of the arbitrator if an application is pending under subsection 5 of section 29A, as well as it relates to the arbitrator being given an opportunity of being heard before the fees is reduced. The crucial subsection for the purpose of deciding the instant lease is subsection 5 of section 29A, which stipulates that the extension of the period referred to in subsection 4 of section 29A may be on the application of any of the parties and may be granted only for sufficient cause and on such terms and conditions as may be imposed by the court. For understanding the purport of subsection 5 of section 29A and the power of extension of the court, this court also finds it relevant to observe that the provisions of section 29A of the Act of 1996, as originally introduced in the statute, mandated that all awards shall be made within a period of 12 months from the date on which the arbitral tribunal enters upon the reference. The explanation clarified when the arbitral tribunal would be deemed to have entered upon reference, namely the date on which the arbitrator had received written notice of the appointment. The mandatory nature of the provisions of section 29A1 and their application to all arbitrations conducted under the Act, domestic or international commercial, was evident from the use of the word shall to inverted comma. In terms with section 29A4, in case the arbitral award was not rendered within 12 or 18-month period, as the case may be, the mandate of the arbitrator would stand terminated unless on an application made by any of the parties, the court extended time on sufficient cause being shown. this aspect of the matter could be also seen from the judgment of the Supreme Court in the case of Tata Sons Private Limited, formerly Tata Sons Limited versus Siva Industries and Holding Limited and other. It's reported.
My lord, it is reported, my lord. I'll get it.
Hmm?
It is reported, my lord. I will get it, my lord.
Reported in 2023 5 SCC 421. The said paragraph 24 is quoted herein, is reproduced herein under. This court further finds it relevant at this stage to observe that after the amendment to the Act of 1996, which was effective, which was given effect to, with effect from 30/8/2019. Section 29A1 stipulated that the award, inverted comma, in matters other than international commercial arbitration, inverted comma, shall be made by the arbitral tribunal within a period of 12 months from the date of completion of the prelims under section 23(4). And this aspect of the matter shows that section 29A1 as amended did not apply to international commercial arbitrations. Be it as it may, from a reading of section 29A5, read with paragraph 24, of the judgment in Tata Sons Private Limited, Tata Sons P Limited, it would be seen that the legislative intent in prescribing the time limit is clear and unambiguous, that the arbitral proceedings, that the award has to be passed within a period of 12 months from the date on which the arbitral tribunal enters upon reference. Bracket or deal? prior to 30/8/2009. Subsection 3 of section 29A gives the liberty to both the parties, to mutually agree for an extension of the time limit within 6 months. By operation of law under subsection 4 of section 29A, the mandate of the arbitrator stands automatically terminated unless extended by the court prior or after the period as specified in subsection 1 and subsection 3. It is the opinion of this court that such extension can be given only on the basis of an application filed by the parties, filed by the party, or filed by either of the parties, by any of the parties, and not otherwise. And that too, for sufficient reasons and by imposing terms and conditions. However, in the instant case, it would be seen that the learned district judge most erroneously and shockingly, on an application under section 14 filed for termination of the mandate of the arbitrator, exercise the power under 29(4) of the Act. That too without even assigning any reason why such extension is to be granted. This court is further surprised to take note of that the learned district judge had gone to the extent of granting one year, have gone to the extent of granting an extension by 1 year. That too when the entire mandate, when the legislative intent under section 29A1 is to pass the award within 1 month, 1 year, within 12 months. Under such circumstances, this court has, as the impugned order, judgment dated 22/3/2022 is on the face of it contrary to the provisions of the Act of 1996, the impugned judgment and order is set aside and quashed. Full stop. This court further observes that the parties are left to take recourse to such proceedings, to take this court further observes that the parties are given liberty to approach the appropriate court in terms with the provisions of what? 29A?
5, my lord.
Should I give you the under 29A? Or should I not mention that?
As per law, Lord.
Because there will be two courts open, my lord. And it can be under 29A5, where parties can again approach for extension.
Now you can approach for extension or appointment of a subsidiary, and he will hear that.
Yes.
Lordship, or either a section 11 read with section 15 substituted.
No. His termination has already happened. Where is the section 15 comes in?
I agree.
So section 15 and 11 do not. So it has to approach under 29A. That's the only way out. Otherwise, the entire other things becomes useless.
Right.
Is given the liberty to approach the appropriate court in terms with section 29A of the Act of 1996. তার উপর একটা প্যারাগ্রাফ এটা লিখে দিব হ্যাঁ এই টেক্সট কিনিলে এই লাস্ট অফ টেক্সট কিনি লেখাৰ আগত মই প্যাৰাগ্ৰাফটো মোক ভৰাই দিব This court further finds it relevant at this stage to take note of section 5 of the Act of 1996, which categorically mentioned that in matters governed by Part 1, no judicial authority shall intervene except where so provided in the part. Under such circumstances, without an application under section 29A, 5 of the Act of 1996, the learned district judge could not have exercised the power under section 29(4) of the Act of 1996, as the same would be contrary to section 5 of the Act of 1996. Oh, one more thing, another thing at the variety. This court had made a specific query upon the learned counsel for the party as to whether any award has been passed in the meantime, taking into account that the instant writ petition has been taken up for instant proceedings have been taken up for disposal in the month of August 2023. And there has been no stay. Mr. H. Gupta, the learned counsel, appearing on behalf of the respondent, submit that the said award have not been published or delivered to any of the parties as is required under section 31(5) of the Act of 1996. Taking into account that the said award have not been published, the arbitral proceedings cannot be said to have been terminated in terms with section 32. 32 na?
My lord. 32. Yes.
Good. Of the Act of 19. That upor bhai dibo. Because this, if I am not putting it later, another problem will arise. Business protocol.
There is a rule. Assam control of felling and removal of trees from non-forest land. Even in case of, my lord, there is a non-forest land, one has to seek permission.
Then why haven't you granted the permission?
One aspect, my lord, remains under, since the plot of land is too big, And going by these rules, it says, well, if a plot of land, if it becomes, my lord, deemed forest, if because it's a if it is a continuous patch of more than 10 hectares and not less having than 200 naturally grown trees, in that case, it becomes a deemed forest.
It is not 10
But it is
hectares.
not more than 10 hectares, it's
Then-
13 bigas. 13 bigas is
15 bigas is less. I think 5 bigas is 1 hectare.
4 bigas.
3.23.
40 bigas.
Huh?
Around 40.
3.23 bigas is one hectare.
Team forest, my lord.
Specific, if I can recall, my lord, the directions given to the revenue was as regards the nature of the land, because there was an averment on the part of the petitioner that it's bit hilly.
So?
That was Lordship had that
Yes, well, what you are referring to?
this, my lord, Assam Control of Felling and Removal of Trees rules, 2002.
Rule. Yes.
Hmm?
Permission for filling of section 5, my lord.
For felling and removal of trees from non-forest land.
So if they demolish, if they cut those trees, then what happens?
They have to seek permission.
No,
and
no,
to-
if they don't take your permission, then
There's a provision of penalty, man.
what is the penalty?
Sure. But that may lead to confiscation
Hmm.
of those timbers.
He says that take those timbers, then
Yes, we are ready to give
Huh?
any royalty.
take the timbers, then
But
What
it
is
is
there?
private land,
And
it is not deemed forest.
Trees part, that is okay, man.
then what
And
else?
also, madam, there's they require art cutting permission.
Cutting, art cutting is from you?
Also, art cutting also they have to
From whom?
art cutting also they have to take permission, madam.
No, from whom? I don't think T.N. Godavaran's case said anything
No,
about
it's not
this,
about Godavari.
because these rules were been made in
Yes.
terms of T.N. Godavaran.
Yes, it is limited to trees, madam.
Yeah.
Art is not there.
So you at best can only confiscate it, nothing more than that. Art copying can only be have a problem by the GMD. GMD has given a no objection. I've asked the revenue says no objection. Then who are you?
Normally, my lord, out of the record, nothing happens. Nobody comes with anything. But there are instances, my lord, in Khanapara side and some other cases are also pending. One has been taken up by lordship itself. Due to this kind of art cutting, my lord, structures are endangered. And then the forest department brought to task that why have you not done? That is
Tell
going.
me, art cutting, does the forest department have anything to say?
Art cutting also, my lord, there is a. There's a card from- My lord.
In minor mineral.
This can be disposed of,
My
my
lord,
lord, because as regards trees, my lord, I am very,
Reason
I am to,
joint verification.
I'm
my lord.
conceding, my lord, need not go to these things. Because trees, I find the department is trying to force it away, my lord, to be very honest. And regarding other parts, my lord, perhaps a written communication on their part would help us because they said it's a hilly
No,
place.
no. As regards trees, I had no problem with it earlier. I am only concerned with the topography which is going to change with the art cut. So that is why I don't. Where is the GMDA? GMDA is a very important point because they only create all problems. See,
Certainly, Lordship has
whatever
taken a
may be,
measure.
the GMDA Act stipulates even the question of why do you need a permission under the GMDA Act, under 25, so that the master plan is not affected. Now, if the master plan, what is the master plan in regard to this particular plot of land?
GMD will know better.
Where is the GMD?
GMD is not a party also.
Party chair. But annex T, my lord, JMD has already given us planning permit.
For
have
annexure
applied
A of which petition?
Petition number 282, annex, page number 22. Annex 3. And after that, we will also pay the fee to JMD, annex 4. For boundary work.
No, this is only for building permit. This has nothing to do with that. This has nothing to do with the permission as regards cutting of hills. Cutting of hills, I think, if it falls under this, you are only concerned with this.
Not all the land is here.
What is your prayer?
Right.
With the mandamus to wanted to accept the joint verification report submitted by the joint investigation conducted by forest and a past appropriate order. May direct the divisional head to consider the report of the circle officer to pass so and so.
Annex 3, page number 26, my lord, joint verification report.
You are concerned with which one?
Both. In the case number 2998, the joint verification. Joint verification are done for both the land.
So we are only concerned with the forest.
Correct.
Huh?
They are no permitted. We have applied for felling trees and art cutting also.
Now, art cutting to forest is no business. We are only concerned with the
But
forest.
in
So we only direct the forest, not to do any, shall,
But
if
in-
required, shall grant the
in
permission.
2998, case number 2998, they have imposed fine for cutting of art. We have not cut.
Where?
The land,
Fine, where?
page number 36.
How
Annex
much?
4, Annex 6, my lord. Actually, we have entrusted an employee and he exhibited some
22
land,
lakhs, 50,000.
2 lakh.
Huh?
2 lakh.
How much?
2,69,050.
Where?
Total part.
Total rates, my lord.
The column, my lord, it starts from
Hmm.
summary, my lord. Summary of minor mineral payment.
2,69,000.
Yes.
They have imposed
Input.
price of minor minerals. What is this art?
Offense report, my lord.
What is this penalty? Under what provision you have taken this?
In page number 41, my lord.
No, under what
Under
provision they
section
have taken
63
this?
and 64 of AMMC, Assam minor mineral concession rule, they have fine imposed penalty.
This is
Which is the letter of 18/9/2017?
89 2017, my lord.
Where?
Page number connection 9 in 282.
You are challenging a communication of 18/9/2017 and it is not a part of the other writ petition where you are challenging 2998.
2998.
It's not there.
Connection 9.
You are not challenging the penalty order.
Yes. In 2998, we are challenging.
Where? Show me.
In the prayer.
Let's read it. Read your prayer. Read the prayer. Show me.
Page number 19, my lord.
Read the prayer.
Issue a direction to refund the penalty imposed by the forest department illegally upon the petitioner
Where?
carrying developing the forest.
Para
If
19
you are
at
to
the bottom.
refund the penalty imposed
My lord.
by the forest department illegally upon the petitioner while carrying developing work over the land. And where is that? You are challenging that 18/9/2017 is where?
Page number 13, clause number 19.
18/9/2017 is which document?
8917 is, my lord,
Where is that?
connection 9.
Of?
Connection 9 of the 2998 and in both the cases,
No, annexure 9 page.
page 50.
Is it 18/9? Where is it written 18/9?
18/9.
18 September 2017.
Huh?
18 March.
Where is it 18?
March, it
This is 1st September. First part.
Yes, Mr. Gogoi, why have you imposed the penalty?
There are rules in place which says, madam. Minor mineral rules are there, madam. If somebody uses this minerals, madam, there has to pay a royalty. Madam. That is another view of the matter. Madam. It has been
Uses the royalty.
who uses this minerals, madam.
What minute? Then-
Minerals means this surface minerals, land. My lord, we have a schedule out there. We have an act. Assam minor mineral concession rules. There's a schedule appended there to my lord.
I've been sitting out here. I know there is an act of 2013.
I asked
Tell
him
me.
to bring, madam.
Where? He has cut what?
No, my lord, if in that be so, my lord, we have to traverse in a different direction because this royalty issue now comes up. And this royalty
Why
issue
is
now
this
comes up.
penalty? You are imposing penalty.
Penalty because my lord, somebody if he uses that land without any permission, my lord, then that if it is used without permission, my lord, land cutting is done without permission, then
Now,
penalty.
show me where is the permission required for land cutting?
I have to, that is a total different direction and I have to.
Oh,
List the matter next Tuesday.
Next.
Prepare yourself. Don't come like this.
They went on different. I was going to consider three parts.
What about the penalty?
Penalty, you have to see, man. No, this is something different because, my lord, there are rulings. If somebody uses land from the patal, private patal, they have to pay royalty, man.
Where?
There is
It
a
is what
judgment,
I
my
state that day, na? There is another matter
But my lord.
where you are asking, the GMC is asking on the basis of
That is
some
different, man.
communication by the
That's-
joint
yes.
secretary.
lord. That is, my lord.
There is
DMC
an
asking-
amendment which has been made to rule
Yes.
3.
That is bad, my lord, because there is double taxation.
Hmm.
One person already has paid.
Hmm.
When they come for building permission, GMC is again asking that again you pay.
No, on the basis of a letter by you. That is the problem. Again, the joint secretary of forest department has issued that.
It is mines and minerals, my lord.
Whoever it is have done that.
That we have to see, my lord, because
They also,
Moreover, we have not transported the land.
that is different issue, my lord. They are.
The land was kept for some purposes, crafted some land. Established some land. And for some own purpose. And we deposited in the same place. We had not transported to other place. But from some information, NXR, my lord, page number 37,
first of all, you have wrongly mentioned in your prayer 18.9. What do I set aside of 18.9? There is no
Actually, my
18.9.
for
Filing
sorry,
repetition
my lord,
just for the
actually, it
sake
should
of
be
it.
passed. It's a-
Let it be on Tuesday.
May I allow to correct that?
And get hold of the GMD.
GMD.
No, let us not go into the GMD. Liberty will be there for other authorities to take.
Yes.
They can take any decision. This is only limited to the forest
But-
and the revenue. Because they are only the part, the direction. Anything else, the GMDA may find. Because one thing I realized, because see, these area, Modgoria area, you have a lot of hills out there.
Yes.
There, these areas have been mentioned as some GMDA has passed a master plan. How is that particular area mentioned? Is it a mention as eco-sensitive or something to that effect? If it is mentioned so, then how can there be a cutting of the hills? So that is why the GMDA has to be, ought to have been there. But if the GMDA is not there, the GMDA will be at liberty to take such action. Because GMDA's permission is not there. You have only asked for building permit, Mr. Sharma. You have only asked for building permit. Building permit is different from art cutting.
I agree.
Find out. And on that day, if we
I will.
so and so, list the matter again on 29th August 2023 for final disposal at 2 p.m. Full stop. Mr. D. Gogoi shall also ask Mr. S. Bora to be present. The S. Bora, the learned standing counsel for the GMDA, to be present in the court. Ask him to be there.
Yes.
May I please allow to correct the date in NXR 10 of
Absolutely no.
Actually,
Item 20.
Very good. Oh, this one. Yes, Mr. I.A. Talukdar. Tell me.
My lord, my prayer before you is NXR 5, my lord, please, sir.
Annexure
5, page 34.
5.
Yes, sir.
Yes.
This is the land which I belong to, my lord, this land was settled by the respondent authority without giving any intimation to me.
Hmm?
So, without giving any intimation to me,
Who are you?
my lord, I am possessing the land.
So is it required?
My lord, since I am possessing the land, so at least for the ends of natural justice, I should be informed. For the ends of natural justice.
The natural justice will be given when you are to be thrown out.
My lord, in respect of other person, the respondent authority invited them and had a meeting.
So, no. Show me the law by which you are to be informed. There's no law.
My lord, I
Then
my lord, my only grievance is before your lord TV.
I have understood your grievance, Mr. Talukar.
Yes.
Your simple grievance is this,
Yes.
that you have been possessing this land from ages. They are also your family members,
Other family members.
other family members,
Hmm.
but the allotment has been given in favor of the respondent number 5,
Yes.
who stays in Calcutta,
Calcutta.
and not to you.
Yes.
That is your case.
And my lord, as per my annexure, all the village elders, village headman has given a certificate that the land is possessed by me, my lord. Annexure
I am
7.
not concerned. You have not approached the authority.
No, I didn't approach the authority because
So why have you
till
filed a
1995, my lord, kindly have a look of the fees I have paid before the authority, my lord. Thereafter, the authority did not collect.
I would have understood that you have also applied for settlement. Have you? Yeah, simple. Mrs. Bora is very simple. Simply, she says that whoever has applied, we have given. Respondent number 5 has applied, we have given.
I thought this is the respondent number 5 has given. But bona fide must have to be decided under section 163, my lord. Bona fide is required. Whether it is bona fide, since I am possessing the land, whether it is bona fide, a person who is residing in Calcutta, it should be given to her.
Hmm?
I am residing about the land having possession. A person who is in Calcutta, whether allotment should be given to in the name of her, my lord.
What is the problem? You are sleeping over your right. Yeah, tell me under 1
63, my lord.
of land for the purpose of cultivation.
Yes.
The disposal of land. What? You are in possession of what land?
Well, TV land, my lord. Tozi land. Government has land, my lord.
For why do you? Settlement has been given for what? Cultivation.
For settlement has been given for in their name, my lord. My lord, kindly have a look.
For what?
My lord. Nothing was mentioned, my lord.
Eh?
Nothing was mentioned for what?
This is for cultivation.
No, nothing, my lord. Nothing was mentioned, my lord. In the allotment order. Page 34.
Hey, land policy. Show me the land policy now, present land policy. Yes, got it.
Land policy, my lord, page 233.
Land policy also does not help you. Yes, madam, tell me one thing. How have you allotted 9 bighas to one person? Doesn't the land policy of 2019 apply to you?
It is settled in the year 2018.
No, it has been given in
It
2000, no, 9/7/2021.
Lordship, a proposal was given in 2018. Proposal was given.
Proposal we are not concerned. You have given on 9/7/2021. Then how could you give 9 bighas to one person? I think the land at best you can give is 5 bighas. Yes, Mr. Bhattaji. 5 bighas.
Yes, no, it's reduced. Now reduced.
How much? Agricultural land?
Maximum of 2 bigha per family.
The maximum of land for allotment to an individual is fixed at 3 bighas for agriculture and half bigha for homestead.
Now, for rural, it is in clause number 4 of 2019 policy.
Where?
Clause 4. This is 2 bighas per family.
No. This is for allotment for allied agricultural purposes in rural. But what do you say about 1.3 for ordinary cultivation?
Oh, yes, madam.
3 bighas. There are provision for allotment of land to indigenous landlords to the tune of 3 bighas and half bigha. Half a bigha does not give them any entitlement to get the land. It is
Maximum of
for the
3 bighas.
government to decide how much land can be given to a person or whether it can be given at all depending on the local circumstances.
3 bighas maximum.
3 bighas. The total can be given is 3.5.
3
3 bighas for agricultural, half
half
bigha
for
for homestead.
Yes.
How did you give 9 bighas? And Mr. I.A. Talukdar has not taken up that. What? Is it for me to help you out? Amend your petition. Take up this ground.
Yes, right.
Then I will set aside and allow only 3 bighas to them and remaining 6 bighas you try your luck. That is the only way out. It's not for me to all do all this.
My lord, at the same time, I pray for your lordship, kindly issue a direction to the respondent to have a copy of the application. My lord.
Huh?
Application copy.
Why?
it may be required, my lord, so that
Let the records, as of now, I don't find any case with you.
my lord, since the application is there, on the basis of the application, allotment was there, that may be, application may be up to me also.
No, I'll ask her to
It is
file an
not-
affidavit bringing on record that application filed by the respondent number 5. That's all.
That my, since it is a public document, at least I'm a victim, I should be sharp so that I can give my proper.
Mr. I. Talukdar.
Yes.
When she files an affidavit, would you not get a copy of it?
My lord, she has filed in the affidavit, but in the affidavit, it was not given, my lord.
That is what I'm asking her to file another additional affidavit. School can't help you further more than that. Giving you a ground what
Yes,
to do.
I'll-
Huh? List the matter after 6 weeks. The learned counsel appearing on behalf of the PTC is directed to file an additional affidavit bringing on record the application filed by the respondent number 5 as well as the orders passed therein by the concerned respondent authorities. Full stop.
Item
14.
I have
Like-
to go, my lord. I have to go. I have given Orion apart. So I have to go before 4:30. I have to. Yeah. So
22.
that matter may 16 may fix any other date. Next Tuesday, 29. 20. 16.
Yours is, what do you want?
16.
You want to go?
I have to go, my lord, because of some religious occasion. I have given Orion to Tanamghar and I have to. 4:30
Item
before
number?
4:30 I have to
Your
leave.
item was 15.
16. It will
16.
fix on 29
No.
or any
List
other-
the matter again on, you have filed the affidavit?
Yes, my lord,
Yes.
I find that.
The receiver is supposed to file an additional affidavit. She is
That also
filed.
I have filed. It is on
Now,
record.
in the additional affidavit, the date of commercial production is mentioned?
So the only registration before the excise is there. The date of
No.
commercial is not-
I have asked her to file.
No,
It
that is
there
not
in the
there.
file, man.
That is that they have
Then-
only declared that
Yes.
like commercial day of.
Excise, yes,
You
my lord.
see,
Excise
No, it is
see,
certificate,
not
you
yes.
must have got some benefits under central excise.
No, they haven't
No,
filed
not yet.
this.
Not yet.
You have not been given any benefit.
Any benefit. Central excise certificate. I have
So
given.
as of now, there is nothing except your date of commercial production.
Yes.
You saying.
Yes,
Correct, that is not, that date is only disputed actually because of certain documents that they have filed with the claim that actually contradicts the whole thing.
regarding
that is the
pollution
problem.
code. My claim was rejected on basis of the.
No,
pollution
Lord say that
control.
land
Certificate
allotment was done on 30th. And commercial date of operation has happened from 27. How can it be, let's say,
Land allotment?
land allotment?
no,
Because it's a new unit.
No, my lord. It is a first floor. It is in the first floor.
Hey, Lordship has seen
Unit
the
extension.
claim application, Lordship. And the
Okay,
report,
okay.
any date, Lordship, that can be.
Sir,
We'll have it on. Let the matter be listed on 14th of September.
15th of September.
14.
Your lordship has actually had the matter, man.
I've heard, but
Had a plan. So a near date fix, my lord.
14th is fine.
no. There's many more matters I've heard.
September 14th. Obliged.
You are getting an early date. Otherwise, I'm giving now dates after November.
Lordship, can be on 15th, Lordship.
No, didn't take the hearing.
15th is not possible. It's Friday.
19th, then 19th.
19th, there are many matters. 14th. 14th is good.
No. Move to
Obliged.
14th.
Yeah, just.
Item 14.
Apply.
My lord,
Yes.
this matter, I tried to get hold of some Supreme Court orders.
Oh, that one.
Yes, my lord. Yes, but I get hold of only one letter which mentions a Supreme Court order passed in the continuing mandamus of my lord Godavarman. But I went to the site also, my lord, I couldn't find anything. And also my lord, the order sheet, which also says, indicates about an order passed by the Supreme Court. But even in the website also, I didn't find it. IA number, there's a IA number, my lord, 548. So it's there, my lord. There's no order sheet.
No, we are concerned with the bark of
Yes, my lord. Yes,
Bagdila, whether there is any order.
Yes, lordship will see the letter that Bhatgila was stopped, my lord. Transportation of Bhatgila was stopped. My lord will see that order sheet I have placed in the second paragraph. It indicates, yes, ma'am, there. It says that some order passed in that IA 548, my lord, which is exactly the letter.
Where
And the second paragraph, my lord.
there is no paragraph. National park in which mining has been carried out was declared as a national park in so and so. After hearing the.
Second, my lord, it starts from the said IA 670 of 2001. First page, my lord.
Yes.
Is an offshoot of IA 1.
Into the detail. Underline good. Maybe say that.
DS, अपने पर उसका bro. এখন look. I'll kindly peruse this letter. It's issued by member secretary, the Central Empowered Committee.
So then,
And then my little that communication, my little bit old. It also speaks of that IA 548.
Oh.
So that communication was, that restriction was placed in
you want to
compliance
go
with
to
this
the
order.
Supreme Court?
Yes, my lord.
You want to go to the Supreme Court
No, no. My lord,
and then face
It-
it out.
I was trying to test out, my lord. If my lord also opens it up now, my lord, there's only one order of 2000. It doesn't open up, my lord.
Prohibited removal of dead, dying, deceased tree from national and sanctuary protected. This order was passed when? In 2002. This order you are referring, this document is referring to some 14 to 2000.
Exactly, my lord. 14 to 2000 order
And this
passed. in-
order which you are referring to is some other order. Or that too, 14 to 2000.
Yes,
14 to
madam.
2000 is not available
Not
in there.
available, my lord. That is the only anxiety, man.
No, no, there will be something. Have you checked it out on the SCC online?
I tried, my lord, and I even went to the site. There's only one order of 2000 which doesn't open up. It says cannot format, but it was. I tried in the morning also.
So what to do?
Lordship will grant me some time, my lord, just a
That
week's time.
2013 matter.
Just a
yours-
week's time, my lord.
Your bark is still lying.
My lord, I don't know, my lord. Actually, my lord, these are perishable goods, my lord.
Then what has happened? 10 years have gone by.
My lord.
Perishable, the petition is also in a dilapidated situation. I hope by the time the next date it comes, the petition remains.
My lord, and the last occasion, my lord, the respondents took the plea that there is a Supreme Court order, and
No, that is gone.
on the direction of this honorable court, they have also produced
Transit
the
pass for
Supreme Court
respond number
judgment.
2 to issue the transportation of already collected Ayurvedic herbs Bagitala outside the state without any further delay. Reach in the matter of so and so to release the collected here. Now, under whose custody? The materials are there for the last 10 years.
If it is perishable, then it is perished, my lord. I have to take instruction of that sort also.
They are, my lord, for 13 years, what they are doing, my lord. For the 2013, from 2013. Cases coming, going, my lord, they are always taking time, always taking
No, I
time.
am not. I was not there,
Authorities, my
I
lord.
was not there. Change of concept.
No. You take your instructions. This is specific. Where is it lying? Lying is where?
My lord, in the custody of the respondent number 2, my lord.
Huh?
Was the direction, it was taken custody, my lord. My lord,
And
it is-
whose custody it is?
my lord, perhaps it is in the custody of SDO.
Huh?
SDO or my lord, it may be range officer also, my lord. I will not confirm, my lord. But at the direction of the respondent number 2, my lord,
You don't know before whom it is.
really, my lord, direction was given, I am thinking.
And is forest the transfer subject?
Yes,
Huh?
no, my lord. Forest, and it is. transferred.
Page 95,
It's,
my
my lord, management of forest, other than reserve forest. It is written like that, if I am very,
Who has it now?
either it is in my lord, it is somewhere in BTC. Either it's in Sirang or that Kuklung range where it was seized. I don't know, Kuklung too.
But
My
you
lord,
are
direction
appearing,
was given to
you are
the,
appearing for the chief conservator of forest BTC.
I can.
Then find out.
my lord,
Here it has been said with reference to that I have the honor to inform you that Sri so-and-so had collected 40,678 kilos of bark from the revenue village area under Kartulung range and so-and-so from the revenue village under America. As per report by the RO so-and-so, the herbal bark are collected from the revenue village area. Secondly, TP can be issued only with a destination to Bongaigaon only. Range officers report and land documents are enclosed herewith. So
And
it is in whose
and thereafter,
possession?
my lord, on the page 95, my lord,
Page?
page 95,
Yes.
annexer S,
S.
my lord,
Yes.
S. By
You
this
are
order,
requested to take the collected area under departmental custody until further order.
my lord.
So
So
the divisional
divisional
forest officer, Srirang Division, Katolgaon.
my lord. As per this honorable court's order, my lord, in the last occasion, they have submitted a petition.
This is gone, my lord. This is,
1997 to SCC.
this is, we are not venturing into that, my lord. That timber
My
part is
lord,
gone.
their contention is that only the Supreme Court has imposed ban. That's why petitioners was not allowed to transport the my lord park. My lord, as per my submission, my lord, there is no such order to not to transport the bark, my lord. It is with respect to trees and timbers, my lord, cutting timber. This is not applicable to our case, my lord, because we have collected bark from the revenue villages, my lord. Earlier, my lord, they have issued TP and we have transport. But subsequently, my lord, they have not issued. This is our case, my lord.
Mr. Day, let us have it on 31st of August. Give them a final chance.
My lord, 31st month, 30, on 30. I have another case, my lord, fixed on 31st.
Where?
In another date,
Where?
well, here.
Okay. We can have it on 12th of October.
Earlier.
Huh?
Earlier, my. Kindly, my lord.
10th of October.
Then it will be gone after vacation, my lord.
Eh?
The vacation. And then also it will go after vacation, my lord, subsequently. May I pray, my lord? 31st August, your lordship is the.
You have
I-
a
I-
matter in the court.
I-
This
I-
court is going to fix at 2 p.m.
My lord,
Then what is your problem?
my,
Okay.
my,
The instant writ petition has been pending since 2011. A perusal of the writ petition, the relief sought for, shows that certain barks that
Patgila
shows
barks.
that
Auxilium.
Bakgila barks, which the petitioner had purchased from revenue villages, from persons from revenue villages, is in the custody of the respondent forest department since the year 2012. The permission to move those works have not been granted by the respondent forest department on the ground of some orders passed by the Supreme Court in that regard. This court on 8/8/2023, while taking up the matter, had posed the question to Mr. D. Gogoi, appearing on behalf of the Forest Department, as regards the specific order of the Supreme Court wherein the transportation of the barks of Bhatgila tree have been banned or restricted. And accordingly, the case was fixed today. However, no such order have been produced. This court, taking into account the submission of Mr. D. Gogoi, grants one more final opportunity to produce any orders passed by the Supreme Court, whereby the transportation of the barks of Bhatgila tree have been prohibited or restricted. This court further directs Mr. D. Gogoi to obtain instruction as regards the condition of the barks of Bhatgila tree, which have been taken into custody by the divisional forest officer, as could be seen from paragraph page 95 of the writ petition. Divisional Forest Officer Srirang Division, Kazalgaon. Full list according on 31/8/2023 at 2 p.m.
Always.
Item number 18.
Good. Eh? Yes. What is this?
My lord, in the year 2012, an NIT was issued by the Indian Oil Corporation for issuing of 114 location dealerships. The dealership on which we applied is on serial number 49 of the advertisement. My lord, post that, in the year 2012, we also have entered with the interview process and given all the documents with regard to the dealership processing.
So you have not got a stay.
No, my lord. But my lord, there.
Dealership has been given to respond number 6.
TJ Mohanty senior advocate.
Huh?
Mr. P. Dutta and Mr. TJ Mohanty, they appeared. No, they were here. My colleague is calling.
Okay, then
My lord, thereafter what happened? That in the first qualifying round, they have found me qualifying. And for a period of 5 years, they have not issued letter of intent to me. Only on 2016, when I inquired about this issuance of LOI, because on the substantial land, I have the development and the boundary walls and other requirements for development of this project. And the amount of 36 lakhs was invested for the project itself. Thereafter, when I asked from 2016 whether the issuance of LOI would be done or not, in 2017, they have denied my LOI, stating certain grounds with regard to capacity to arrange finance. My lord, what?
so your LOA has been cancelled.
No, my lord, my LOI is not issued itself.
Oh,
They have, before issuance of my LOI, on which they have issued me a letter that I cannot be issued an LOI because in my documents, capacity to arrange finance was not done. They've issued, my lord, may come on the letter itself on which I'm challenging.
and they gave it to respond number 6.
My lord, that's not the thing. Another verification round was done in which they found a,
Where is it?
my lord,
Where
the
is the document?
annexure 6, page 39 that I'm challenging at first.
Hmm.
It says in the paragraph number 1, please refer to your application received for award of the above mentioned dealership and interview held on 27/12/2012 at the Divisional Office. Subsequently, field verification of your credentials was also conducted, but variations were observed under the parameter capacity to arrange finance. My lord, then if we go in paragraph 2, A, B, and C, the wrong contention that has been held for rejecting my dealership. My lord, the first is that there had to be balance. I have stated my balance was 20,345 and they found it 15,345. Later on in the B, there is no problem with B, but when it comes to the C, it says that there was a joint account, that is MS Gita developer, the C number, fund shown in current account number so and so. My lord, with this also I have clarified that this is a family run business at that point, the account which I have given, and that family
When was the response number 6 being given?
17, 2017, my lord,
After 5 years.
after 5 years. But there are also discrepancies, my lord. With regard to that also there are discrepancies because the land that was submitted by him for development, first of all, that is also in question because the title suit is pending over that land. Second of all, there was a complaint by the owners of that land who have filed the title suit before the IOC that this development project cannot go further because of this pendency of suit. Thereafter, there's also another discrepancy, my lord, that the development project in whose name he has taken was individual name. But later on, upon verification, it was found that for this very project, he entered into a partnership deed with a person named Amrit Chetri, my lord. And this person, later on, after the filing of a writ petition, when the notices were served, they went for the dissolution of this partnership. Way after, in the year 2018, my lord, these facts were also not brought into grounds. Now, the yardstick that they have hold, the incapacity of funds for me to complete this project. My lord, I have given documents which shows I have 80 lakhs of rupees in my disposal by Assam Gramin Vikas Bank, and there's another bank, my lord, that has given me bank surety of funds to be provided to 80 lakhs. 10 lakhs with friends and family fund, and another 60 lakhs from bank credit facility. Thereafter, my
How
lord,
have you shown that 60 lakh?
my lord, may kindly be with me.
And what is the clause as regards the financial stability?
My lord, that they have brought that is not the only ground, my lord, the financial stability. This they have held it, but later on when they filed their opposition, they've also got other grounds that there was an agency pending in my family member's name also. So that is also another ground that cannot be given. But that was terminated before in the year 2010. That termination is also.
We are concerned with only financial.
They are concerned with financial. My concern is only with financial.
Yes, where is the financial condition? Which is the regulation at that point of time?
My lord, they have to be appointed
Where have you enclosed?
under the broader selection of petrol diesel retail outlets. That is in page 80.
Yeah.
Page
Got
80.
it.
Page 80.
Yes. What
Hello,
do you
the
want?
other
Page
page from 80 it begins.
80.
Yes, sir.
Yes. Where is the financial condition?
My lord, how it goes is that they allot 100 marks to the person when they find the criteria to be fulfilled on different heads.
Hmm.
My lord, when it comes to finance, page 89, if my lord will go. Page 89, my lord. In the parameter section, the second section, that is capacity to provide finance.
Hmm.
And then there is a marking system of 25.
Hmm.
When this later evaluation was done, the second evaluation, in which the respondent 6 was found to be successful. In that process, my lord, the discrepancy that held was that in the first process, they have given me marks for having the enough cash funds, but not in the second
Your
one.
problem is with ready availability of finance.
Yes, my lord, I have ready availability of finance. At that moment also, I very well have. In
Where
fact,
is that impugn order?
my lord, page 39,
Eh?
39 of my report.
39.
Yes,
Capability to arrange finance.
my lord. This,
Capability to provide finance.
my lord,
25 marks.
my lord.
And how much did he get? Mr. Bharadwaj?
That is the total mark. That is the total.
We are only concerned with page 89, the second portion. First portion is infrastructure he has,
Yes, my lord.
educational qualification he has.
Yes, my lord.
Only problem is as regards the finance, that is B. The second one, financial soundness. That's it. So that is 20 marks,
Very good.
25 marks.
My lord, may for a moment be with me on page number 123 and 124, my lord, turning page. On that page, they have given the parameters of the first evaluation process, the second evaluation process, the marks that were allotted the first and then second. It's all
Eight,
page 124 and 123 and 124. 123 will portray the total marks that
what
I've
is your
got.
name?
My lord,
What is your name?
my lord, my name is Ajit Chandra Datta,
Oh, you got 69.
68.97.
Capability to finance, he has got 0.
My lord,
Liquid cash in the form of bank balance, fixed deposit, shares of Iman, max 12 marks. He has got 0.
Hello.
Fixed and movable assets, including own land, buildings, vehicles, etc. 4 marks, you have got 0. Oh, because of these zeros, you have been out.
also because of the first criteria, that is the marks awarded for land evaluation committee. My lord, here I have given only 91 marks, whereas the respondent 6 is given 89 marks, my lord. Only
Hmm.
difference of 2 marks. Whereas my land is owned by me, developed by me, and there is no third person or third rights to be developing here. Whereas the land that is developed by the petitioner number 6, that land is a leased land, my lord. And the lease rate is also an
Okay, we see another 8 marks has to be given to you.
my lord.
Are you saying that? That's all.
My lord,
Nothing more than that. Total is 100.
my lord, I
You have already got
credit
91.33. So another remain is
Then a couple-
8.67.
Well.
So let us add 8.67. That is what you want.
Okay, okay.
Then what about the other two? The capability of finance?
My lord, that I have provided the documents for which they have said that they cannot honor those documents because there is no valid CA certificate. Whereas, my lord, the performer in which they have been submitting our tender bids is same and follows for all. And everyone in that document has provided in a similar manner. My document in which I provide my credit facilities and the surety that I have liquidation of funds, my lord.
Yes, Mr. Das, what are you waiting for? 15 is for what? What matter is that? Huh? Transmission. Did I hear that? Earlier, no. Hmm? Then have you gone through it? We'll have it on some other day. When? We'll have it on. No. Next Tuesday, no time. We'll have it on 19th of September. 19th September. So now we'll hear this matter some other day. You're running. You're close. You have an urgency. Another? You didn't give list mark. You did not give any mark to 12. Huh? So did you mention in your thing which will be the date on which it will be considered? So the date was considered on 24. No, have you mentioned when should it be the amount? On the date on which he submits the year or on the date of no, it is not false. He has made a false statement.
No, my lord.
Yes, it is a loan. Yes, it is. There is a liability. And your land, there is a suit pending. But there is a suit pending. Not for this land. And this land is a part of it. And the land was, that particular land is a part of it. If that is a part of it, and have you taken the no objection for other? No, because isn't that required? As per your clauses, if it is belongs to many persons, then a no affidavit or no objection has to be given. Have they given? If that land is a former part of a group of parties. I get clever every day from because of your submission. No, he in the other matter, Mr. BJ Ghosh, you have taken that down. Oh, that matter is there. Oh, that Hitler is. And you have called the new matter. That matter I've already heard. You have got the records. Is there any affidavit by them? Huh? Mr. Ghosh? No affidavit.
At the time of field verification, all the documents are submitted, my lord. Let's say the report, what the report said, field verification report.
No, there is no on the records, there is no document to the effect. Because you see, I would have understood if it is a case where you were 25, 30 years. I would have understood your child may be a minor, but you are 56 years old.
Field verification report. There is a report, my lord, which was made during the field verification, when they go to the field. At that time, all the documents are submitted. That was why is the report, they made a chart. Whatever the document they have received.
No, those documents, can
Yes.
they submit any documents subsequently? No,
At the time of field verification, my lord.
no. You have to submit all the documents at that time of filing this application. That- And that document is not there. You give that record. Dispose, dismiss. Pass the order. Yes,
Can I
now
have a
be-
look?
huh?
Record, my lord, for my statistics? Can I have a look?
Please do.
My lord?
Give it. to
Hello.
Dismiss. Because otherwise I was in your favor.
Lord,
Even without you being present, I granted
I-
a
I-
stay.
I oblige,
Huh.
Lord, for-
But here, when you are 56 years old,
Yes.
then it struck me.
Yes.
Then your right is only 1/8.
on it. I'm like,
Then obviously without a no objection, it becomes very difficult.
"Hey, punishment, sir."
And just give me the clause number, huh? Take on file to Take. Give it to him. You just mark that area with the yellow. In the brochure it is there. Just mark that clause and put the tag out there. I'll pass the judgment. Yes, now being clever. Yes. Yeah, man. If it is a dispute, matter is for partition, then how do you take care of that? Then is it given? Not necessary.
My
It
lord,
is not, but he has challenged. There is a
Yes.
suit.
it's there, my lord. Page number 160, it is there. One of the party of that suit has objected to the corporate not to issue this dealership to them. She has expressly said they have not obtained the consent for it. It's there, my lord. Erected
Then how are you giving? Isn't it required? Let's see that.
page 160, 161.
No, where is that clause out there
Clause
in the
of-
terms?
NOC.
Yes. Then the problem arises regarding length. Educational qualification. Where is the land?
What?
Land clause. Clause will be here.
Field.
Yes. Interstate penalty land. Firm offer of land. Own land. 20. Since availability of suitable land for setting out of retail at the advertised is the essence of the project, wherever IOC has advertised that it is also needs land at the advertised location. Applicants who readily have suitable lands available for setting out of a retail outlet or have a firm commitment from the landowner for purchase, lease of site, considering the location of the land from the point of view of the suitability from technical and commercial angle and rates acceptable to IOC. However, the land and details offered along with the application alone will be considered for this purpose, and the applicant will not be given the opportunity to offer any other land subsequently. For this purpose, the land owned by the family unit will also be considered as belonging to the applicant, subject to producing the consent or notarized affidavit signed by all concerned members of the family unit. Then, how could you have done it if one of the family unit is there?
Page 1, see the page 1, see the object by the member.
Unless he says that he shows his absolute right. That's the only way. I got your ground.
Right.
Arguing on it. That they also in that matter. What happened that matter? Residential status. Huh?
Now,
They should be given. Then
now,
if it is state, then it is bad for the petitioner. Na? It is better for him. But he duly accepted that. And he participated in the second round.
put a
Anyway, so here that also the judgment I had to find out on residential. So here we will hear on some other thing. You just find out how do you take care of that, and whether records are there for notarized. List the matter again on 31st of August 2023, on which date Mr. T. Bhargava, hearing on behalf of the IOC, shall produce the records with respect to the selection of the LPG distributorship, and well as also take instructions as to whether the land offered by the respondent number 6 was the individual land of the respondent number 6 or of the family members, and if so, and if it is the land belonging to the family member, then as to whether there has been notarized affidavits filed from the members of the family. That is dismissed. I'll pass the order to this. Oh, retail. Chalo, we'll have it on 7. 7.
It doesn't mean that's a failure. It doesn't.
Time दिया जाना है
Basic. 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 Basic.
Live to one question. Live to one question.